Welcome to the Foul Play YouTube channel, Open Mic Edition 114.
Hey, you nailed it. That is right. Thank you, Susan. Sugar.
You bet.
This,
You bet, honey.
This is Open Mic 114. Continuing on today again with Colborn v. Netflix documents that Cherie got us. And this seemed like a never-ending trail of paperwork. Can't imagine Ludwig's enjoying this, but probably about as much as we are. But we have found out some interesting things in this seemingly never-ending case. So with that said, we're going to start back here in a few minutes. We're going to start right back where we left off last night in the interrogatories. But first, let's get to it and let everyone say hello that's here in Discord. Alice?
Hello, lovely panel. Good to be back. Hello, everyone in chat. Good to see you. And can't wait for the laughs that we're going to get tonight with all this shite. So,
No doubt. Thank you, Alice. And Cherie, lovely Cherie.
Hi, everybody, and welcome to Open Mic.
Thanks, Cherie. And Sugar?
Hello, everyone. Let's get this show on the road.
There you go. That's exactly right. I know Doc wanted to join, but I think he's got some things going on. He may try to come in, I think, if time allows. And then, everybody's got things to do. We're missing Rhonda, but I'm sure she's busy with other things, and, people are asleep and so forth. So we'll pass around and share the reading duties as we go through this. First today, or before we get to that, let's say hello to everyone in the live chat that I can see right now. I see Maz. Hey, Maz. Case 10. There's the Catnet. Super Mud. Who else we got here? There's Cher. Behind the Magic. Who else we got? There's Cloud Cooley. There's Neverly. Neverly's probably still doing some kind of surgery. So she's probably trying to listen in.
new name, Jack, that I haven't seen before, and it's Mary Kopp. So, hello, Mary. Welcome. Thank you for joining us.
Yep. Thanks so much for coming along and listening in. So I'm sure that we'll probably pick up more as time goes. People, are working and so forth. It is dinner time here in the States. So
Anthony D's just joined us. So
Yep. I just saw Anthony. Yep. Okay. Let's get going here. But before we start, I should have put this up last night, and I started to in times past, but interrogatory, which is what we're going to be starting on, that is a legal term, and I'm going to put up on the screen here just for a second what an interrogatory is, and it's very brief, just take a second to read it out. It just says, what is the purpose of an interrogatory? And it says that interrogatories are a discovery tool that the parties can use to have specific questions about a case answered before trial. Interrogatories are a list of questions sent to the other party that she must respond to in writing. So that's basically what we're reading tonight, or we're going to be reading tonight in this first document. Just wanted to explain it because, back, I knew what it was, but back, at some point way back whenever, I heard the term interrogatory. I didn't know what the hell that was. I knew it was a legal term, but I didn't know what it meant. So there you go. Now you know. The more you know, right? So let me get this document pulled up where we left off last night. And all right, that's going to pop in. So we were going to start on number 11. So for tonight, starting out, at least some of these, we can share the burden here. Cherie, can you read the actual interrogatory, and then Susan, can you read the response?
Sure.
You guys start whenever you're ready.
Okay. Interrogatory number 11. Identify every healthcare provider that you have seen for treatment of any condition or conditions that you believe was caused or exacerbated by making a murderer. And for each, describe the nature of the symptoms for which you sought treatment, the diagnosis you received, all medications you were prescribed, and all treatment and therapy you received, and the dates of the treatments and therapy.
Response. Subject to his general objections, plaintiff designates his previously produced healthcare records in response to this interrogatory, without waiving the confidentiality designations in said prior production, which are incorporated by reference herein. Plaintiff further responds that he has seen the following providers that he has seen for anxiety relating to the effects of MAM. Teresa J. Krugerjunk, NP, of Prevea on December 28, 2018, noted as having quote unquote presented for anxiety. Follow-up June 28, 2019. Plaintiff has taken buspirone, Busvar, as a result of his anxiety caused by MAM. Plaintiff believes that the stress is also adversely affecting his blood pressure, for which he takes lisinopril. Damages are ongoing, and plaintiff reserves the right to supplement this response. 2018, huh?
Yeah. I think we should say note that if memory serves, and I'm 99.9% sure I'm right, he didn't see a doctor till after the lawsuit was filed. I think that's right.
That's right. Yeah. December
Yeah.
28, 2018.
Yeah.
Mm-hmm.
Oh, this might be the last of. That may be the last interrogatory. Hey.
Yeah, and then it's the chart. Yeah.
Hey, looky there.
Mm-hmm.
Okay. So yeah, and we're not going to read through. We'll just scan through them right quick.
Yeah.
We're not going to read. We're not going to read all these because we've seen these. Yeah, we have. I remember reading several of these before, so there's really no point in reading them again. This is page 10 of a 49-page document, and I'm just going to roll through them. Yeah, remember they talked about Glenn. I remember all this. We looked at it and read many of them. Yeah.
This is all Colborn stuff.
Yep.
You think that Colborn would at least have the smarts to seek medical attention before filing the lawsuit? It just looks shady doing it after.
It looks really shady, especially if you're claiming it in your lawsuit.
Yeah,
well,
exactly.
MAM premiered. It was 2015.
Yeah.
Yeah.
And he got all of those calls and complaints and death threats or whatever he says, and he didn't seek. It didn't bother him for 3 years.
Yeah, exactly, Susan. But not only that, 2019 is when he started dipping his wick in somebody else's. You know what I mean? So that's what's probably gave him the stress, because the wife found out about it, the kids found out about it, and they basically disowned him for it. That's when his anxiety started, in my opinion. No, because of MAM.
When you got issues with your zipper, that can cause all kinds of stress, Alice.
Well, true.
So that's the year that he started the affair. I didn't recall that.
It was either 2018 or she found out in 2019, but we don't know I don't think we know exactly when the affair actually started. But
right.
Yeah, This is, I'm still continuing to roll through. This is from document 105, way. This is from back in 2007, or maybe even, well, I'm not exactly sure when it is, but it doesn't matter. We're not going to. But I think there's a section in here I do want to look at and read. There's, Couché. Yeah, I think this is from the depositions in 2005. I'm 99%. There's Kelly and Rohrer. They've included all this, and then I thought there was a section here, the string talk. Yeah, this is some. That's what this is. This is summaries of the different episodes, and that's it. They're yeah. So there may not be anything here that I want to look.
Yeah, I'm pretty sure we've been through all of this.
Yeah, these are all. And then Exhibit B, I remember this too. This has been months ago. We looked at.
Yep.
We're up to page 36. Long presented. Yeah, again, they're still talking about making a murderer. And, pulling in all this other outside stuff it's just crazy. And it adds to, again, I think a little bit of, actually quite a bit of it's just kind of scuzzy to try to include all these other outside people that have nothing to do with Colborn. And they did that a lot, especially Griesbach. He did that. And they're still kind of tried to do it even. And they have absolutely
it doesn't make sense.
Well, they're just piling on at that point. To me, they're just piling on.
Mm-hmm.
Yeah, and this is more. I don't think there's anything here that we haven't.
I don't either, Jack.
Yeah, that's the end of that. So we're going to put a pin and say we're done with 344-5, and we're going to move on to 344-6. And 344-6 is remember, we've looked at this too. These were highlighted portions of Griesbach's book. We've read this. Now we can the other copy that we had, the portion was highlighted. I mean, if you guys want to read it again, we can, but I just don't see it.
I don't either. I mean, we know what parts. Geez, yeah, this isn't highlighted at all.
No, I don't know. The highlight portion didn't carry through on the copy. But I know that the one that we exhibit, whatever the hell it was before that we read, it was highlighted. Actually, quite a bit of this one. Looks like about 6 pages here, 5 or 6 pages. I mean, if you guys want to read through it, we can. Yes, no, move on.
What's the consensus? I don't care either way, really.
Yeah, me either.
Same here.
What's the chat want to do?
Do you want us to read it, chat?
Yes or no, chat? Read through it or move on? Matt
Move
says
on,
move on.
please.
Matt says move on. Yeah, no one's saying jumping up and down saying read it. So that's kind of what I figured. I know we've read it before. Yeah. All right, we're going to move on to 344-7. This is the last attachment for document 340. And this is, I'm pretty sure Tyson's testimony at trial. It says it's a 6-page document, but ultimately I think there's only a couple pages of Tyson's testimony. So I think we should.
Okey-doke.
So I'll be the court. Obviously, Sugar, you can be Kratz.
Kitty.
Yeah, nobody can do crap like Susan.
No, she's here. She's here, so you know. Alice, if you want to read Tyson's part.
I see the clerk. And
Yeah, well, sure, you can do the clerk. I'll be the judge. And yeah, I think that should pretty well cover us.
And who do you want me to be? Tyson?
Tyson, you're going to be Tyson. So.
Right, okay.
All right, here we go. I'm going to start on line 2. The court, very well. The witness is excused.
Could we approach just briefly, Judge?
Sure, Sugar. Take the sidebar.
I'm going to call.
Yeah.
I'm going to call Bill Tyson to the stand.
Please raise your right hand.
That's still you.
Sure.
Please be seated. Is that where I am? Okay, please spell your name and spell your last name for the record.
William Tyson, Tyson.
Mr. Tyson, how are you employed?
I am a sergeant with the patrol staff with the Calumet County Sheriff's Department.
As a sergeant with the Calumet County, were you asked to assist in search efforts at what's now called the Avery Salvage Yard?
Yes.
All right. Now, you said that you were teamed up with, or that you joined other officers. Do you remember who was in your team?
Yes, it was Lieutenant Jim Link from the Manitowoc County Sheriff's Department, Sergeant Andrew Colborn from the Manitowoc County Sheriff's Department, and Detective Dave Rimmaker from the Manitowoc County Sheriff's Department.
Was there any discussion about what each of your responsibilities were going to be? And I guess more specifically, was there a discussion about who was in charge of this team?
It was told to me that no Manitowoc County deputy should be alone on the property. Investigator Uyghur told me my responsibility would be to go with them into the Stephen Avery trailer and to document what they were doing, take notes, and if evidence was seized by them, to take custody of all the evidence at the end of the search warrant.
Do you know why a Calumet County deputy was put in charge of the custody of any physical evidence that might be obtained?
It was told to me that Investigator Uyghur would be the lead investigator and that the...
Yeah, and so why did the Manitowoc police go into that trailer?
Because I had to be a babysitter. For police officers, I had to be a babysitter. Can you believe it?
And can you believe the time he took to have them explain that they couldn't be alone? They had to be watched. How scuzzy, how scuzzy that is. If you're going to have to watch them, why do you have them on the property? You know?
Yeah.
It's madness. I mean, the fact is they should not have been on that property, period. No one from Manitowoc County Sheriff's Department should have been anywhere on that property. Whether it was collecting, whether it was just support whether it was resources or not. Any one of them.
As that Doc said last night, we wouldn't be here right now if Colborn.
Exactly, Susan. Yeah, exactly. If they'd have done this properly and none of them were on that property whatsoever, where you couldn't definitely see that there is a clear conflict of interest with them being on that property, then yeah, we wouldn't be here. We wouldn't be talking about it. But that's the
And
state.
Stephen and Brendan would not be in prison, more than likely.
Yeah.
Yep.
Or they probably would be in prison, Susan, because that's what they wanted, no matter what. They wanted to get Stephen in prison. But
Wow.
they did not think that this case would be scrutinised the way it's been scrutinised and the way the documentary has been scrutinised and all. They did not think in any way whatsoever that this sort of thing would happen and that people would start asking questions about the convictions of these two guys. You know what I mean? They thought, you know, that's it, done and dusted, slap my hands, wipe my hands, we're done, you know. Not for a minute did they think that this was going to get as scrutinised as what it has.
No.
Yeah.
No, man. The truth is, Manitowoc County should not have been on the property at all. They shouldn't have been involved.
Period.
So, no, period. That's right. So, yeah, that was an interesting little read there. I thank them for bringing that forward and reminding everyone again. Anyway, so that one's done, and we're going to move on to where the hell are we at? Yeah, 345. I want to make so
345. Is there a 345?
there is. It's in the open mic text box text room. Better be.
You didn't put 45.
What the hell's wrong with me? Hold.
There's 46, 47, 48.
I just skipped.
It may be something really brief. I don't know.
It's in there now. I skipped right over that damn thing. I see it here. There you go. Now it's in. Okay, so let's move on and get this one. Cherie, can you read? This is looks like a 3-page document.
Yes, I can. Are you ready now?
You start whenever you're ready.
Okay. Defendant's joint motion to restrict. Pursuant to General Local Rule 79D, Defendant Netflix Incorporated, Chrome Media LLC, Moira Demos, and Laura Riccardi, collectively the defendants, submit this motion to restrict in connection with their joint response to plaintiff Andrew Colborn's additional proposed findings of fact. Joint response. In support of this motion, the defendants state as follows. Pursuant to the court's order granting the parties joint motion to amend the scheduling order, the defendants are filing their summary judgment reply briefs today, December 9th, 2022. As part and in support of their summary judgment reply briefs and in compliance with Local Rule 56B3, the defendants file their joint response to plaintiff Andrew Colburn's additional proposed findings of fact. Therein, the defendants cite to certain materials in the record filed under restriction and on which the court has not yet ruled. Because these records were designated confidential by parties and other than the defendants, they take no position regarding whether good cause exists for them to remain restricted from public access. As the joint response discusses the content of a currently restricted document, the defendants now file a redacted version of the joint response conventionally and an unredacted version under restriction. Respectfully submitted, Lita Walker.
Wow, that's interesting. A joint motion. Comments? Susan, Alice, anything? I don't really have anything for this.
Sorry, I had a phone call.
That's all right. Yeah, I mean, it is what it is, I guess. And basically, they're amending the scheduling order. So, all right, it is what it is. Let's move on. And this is, we're on to document 340. This is oh, wow. This is 100. I was wrong. I guess I thought that said 15-page document. It's 157.
Good God. What is it?
I don't know.
Joint response. Additional proposed finding of fact.
Joint response to plain Andrew Colborn's edition.
The general objections, number 1. God, Jesus. Violates local rules. Court should disregard it.
Let's see. I'm looking to see if we can find a spot here. I guess we can read down to this where it says we can read all the above because it looked like they outlined several things down to this Roman numeral 2. Susan, you want to read this section? Looks like it's a couple pages, not that long.
Starting where, Jack?
At the top.
Okay. Let's see. Defendant's joint response to plaintiff Andrew Colborn's additional proposed findings of fact. Pursuant to Civil Local Rule 56B3B, defendants Netflix, Chrome Media, Moira Demos, and Laura Riccardi, the producer defendants, collectively the defendants, by and through undersigned counsel, for their response to Andrew Colborn's additional proposed findings of fact, CAPFF, state as follows. General objections. 1. Colborn's 17-page, single-spaced, unenumerated addendum violates the local rules, and the court should disregard the addendum and all references to it in Colborn's opposition papers.
That's the one. I'm pretty sure that's the one that Rhonda read last night. It's one of the first ones we read. And I'm pretty sure it was 17 pages, and it was not numbered. Anyway, go ahead.
And single-spaced.
That's right.
Incorporated in Andrew Colborn's memorandum of law in opposition to the defendant's motion for summary judgment, and appended in a longer format to his responses to the defendant's respective proposed finding of fact, is a document titled, quote-unquote, Addendum to Response to Defendants. Proposed findings of fact, episode summaries, the addendum, page 3 through 27 of the opposition, are an abridged version of the addendum that then cite to the addendum itself as the supporting factual record. The addendum, a 17-page single-spaced, unenumerated, quote-unquote, summary of Making a Murderer, is improper for at least 4 reasons. As set forth fully below, defendants object to the addendum and respectfully request that the court disregard it. First, civil law rule, I don't know, 56B2B.
It's local rule.
Local rule does not permit such a document to be submitted or considered by the court on summary judgment. That rule contemplates, quote, a concise response to the moving party's statement of facts, end quote, and requires reproduction of each numbered paragraph in the moving party's statement of facts, followed by a response to each paragraph, end quote. Colborn purported to file such responses at dockets 324, 323, 324, and 326, and he filed his 95 additional statements of fact at docket 325. but nothing in the local rules contemplates the third quote-unquote factual document Colborn filed, the addendum. The addendum does not include cross-sides to the various statements of fact documents, nor do the statement of fact documents address all the facts in the addendum. As a result, nothing in the local rules provides to the defendants a mechanism by which to respond to the allegations contained therein. The addendum and any reference to or reliance on it in the papers Colborn filed in opposition to defendant's motion for summary judgment, therefore severely prejudices the defendants. Colborn had the same opportunity as any other litigant, including the defendants in this case, to number one, respond to the moving party's proposed finding of fact, and two, put forth 100 additional material facts in his CAPFF. He did both, and he submitted the addendum, which those same rules do not contemplate. Accordingly, the defendants do not respond to Colborn's improper addendum, and the court should similarly disregard it. Second, the addendum is neither competent evidence nor a factual document. Rather, it is attorney characterization and argument. Citations to the addendum in any of his opposition papers are therefore improper. Ma'am speaks for itself, and the court must consider the challenge statements in the context of the whole 10-hour series. General objection number one, for this reason, two, the defendants object to the addendum's consideration and any reliance thereon in Colborn's opposition papers, and respectfully request that the court simply watch the series. Netflix previously filed all 10 episodes. Third, to the extent Colborn wishes to rely on the addendum for purposes of asking the court to make findings of material fact regarding the content of MAM, he should have done so under the procedures provided in the local rules. It was incumbent on him to describe the portions of each episode on which he relies in opposing the defendant's motion for summary judgment in separately numbered paragraphs, limited to one material fact per paragraph and with timestamps to each passage from the series. This is what defendants did in their respective statements of proposed finding of fact. For example, to show the many instances in which Ma'am portrayed a pro-law enforcement, anti-Stephen Avery perspective, such that no reasonable viewer could have concluded that Ma'am was adopting or endorsing Avery's frame-up theory. Let's see, I'm going to read the footnote. Indeed, out of an abundance of caution, Netflix made its summary of each material fact from Ma'am's episodes its own, individual, enumerated paragraph. Doing so used 59 of Netflix's allotted 150 facts as permitted under the local rules. If Netflix had believed an unenumerated addendum was proper, it undoubtedly would have used those 59 items to address some other topic. Had Colborn done so, he would have far exceeded the 100 fact limit on the quote-unquote facts in the addendum alone. His failure to follow the procedure set forth in Civil Local Rule 56 should not be rewarded, and the court should decline to consider any quote-unquote facts to the extent they appear only in the addendum and not in the CAPFF. Fourth and finally,
just before you start that, Maz is asking in chat what addendum is. Addendum is an item of additional material added at the end of a book or document, typically in order to correct, clarify, or supplement something the group has issued. Quote, the group has issued an addendum to the letter. So it's like clarifying stuff or correcting issues or adding something to, and that's what addendum means.
And they're saying that
And they're saying, yeah,
go ahead.
They're just saying it's not proper. They can't
Correct.
do that.
Right. Legally, it's just improper.
Yeah. Jeez. You'd think as lawyers they'd know that. Fourth, and finally, to the extent Colborn's addendum includes statements from the series which were not expressly pleaded in the body of his Second Amendment complaint, or even either of his exhibits, these statements are not at issue in this case because Colborn has failed to properly plead them. General objection number 2. It was Colborn's burden to properly plead and put at issue all of the statements from Mam he is challenging in this case, and he had 3 opportunities to do so, including his original complaint filed on December 17, 2018, his amended complaint filed on March 4, 2019, and his second amended complaint filed on January 3, 2020. Accordingly, the defendants dispute the materiality and the propriety of any statements which appear in Colborn's addendum, but which were not pleaded and therefore not put at issue in the second amended complaint. Number 2. The court should disregard any additional proposed findings of fact beyond the 100 that the local rules permit. Colborn has violated Civil Local Rule 56 in at least 2 other ways as well. The rule includes an express limitation on the number of additional facts that a non-moving party can put forth without leave of court. It also directs that each additional fact must appear in a separately numbered paragraph and, quote, be limited to one material fact, end quote. Colborn fails to abide by either requirement. Colborn did not move the court for leave to file more than 100 facts in response to the defendants' respective motions for summary judgment. Instead, in an attempt to evade the 100-fact limit, the vast majority of Colborn's proposed facts are improperly compound. And as one example, number 74 includes 6 single-spaced, unenumerated bullet points that run for more than a page, where Colborn attempts to summarize several scenes that he alleges distort his real-life physical reactions. At bare minimum, each supposed quote-unquote example included in number 74 should have been a distinct enumerated fact. This alone would have put Colborn over the 100-fact limit under the local rules, given that he started with 95 additional proposed facts. Yet another example is number 46, in which Colborn attempts to propose as material facts the contents of at least 14 voicemail messages. Breaking these 14 voicemails out into their own distinct enumerated facts would again have exceeded the 100-fact limit of the local rules.
This is why I love Lita Walker. She don't miss shit. She doesn't miss a damn. God almighty. Anyway, go ahead.
They were sure trying to cheat, weren't they?
Oh, big time.
Jeez.
I mean, I'm glad she's doing it because as a layperson, I wouldn't have known. Absolutely.
Right. Wow. Colborn also fails to include in his CAPFF all of the actual additional quote-unquote facts he cites in responding to the defendants' respective statements of proposed findings of fact, allegations that appear nowhere else in the summary judgment record. The problem with this is twofold. First, on reply, the local rules do not permit for defendants to respond to Colborn's quote-unquote response to their facts. Rather, the rule allow only for a response to Colborn's CAPFF. By failing to include the new quote-unquote facts in his CAPFF, Colborn denies the defendants a mechanism through which to respond to those facts. Second, the rules allow only 100 additional facts to be introduced on opposition to a motion for summary judgment. By not including the new quote-unquote facts, From his response in the CAPFF, Colborn again evades the strictures of the local rules with which defendants complied. This is improper gamesmanship that prejudices the defendants. You bastard, as Alice would say.
You fanny, you bunch of fannies.
You fannies, bunch of fannies. The defendants object to both of Colborn's flagrant violations of Civil Local Rule 56B to BII, which it believes are sanctionable. It is entirely within the court's discretion to read to whatever it considers to be the 100th fact in Colborn's CAPFF, properly counted, and then stop reading, and to disregard portions of Colborn's opposition that rely on facts that exceed the limit of the local rules. In any event, defendants have responded to the 95 items Colborn listed in the CAPFF, notwithstanding their compound nature, and they've also painstakingly identified, listed, and responded to each of the new facts Colborn included in his response to the defendants' respective statements of proposed findings of fact. It has assigned each of these quote-unquote new facts in its own number, starting with number 96. Number 3. The court should rely on the best evidence and ma'am, and the parties' communications speak for themselves. Defendants generally object to Colborn's characterization of ma'am and the parties' communications and instead ask the court to rely on the best evidence. Ma'am speaks for itself, and the court must consider it as a whole and in context. Similarly, the parties' communications speak for themselves. As one example, defendants demonstrated in their opposition to plaintiff's motion for partial summary judgment that there are a number of transcription errors, both material and immaterial, in Colborn's cross-motion papers, as well as misleading use of quotation marks for words and phrases that don't appear in the underlying evidence. Moreover, Colborn regularly selectively quotes from portions of several unrelated documents, representing them as if related or from a single document, and or removing the quoted portions from their context, attempting to impute use of the terms key villain and mastermind as against Colborn, when the notes make clear the individuals to whom they are referring, which are expressly not Colborn. These examples underscore how Colborn's characterization of ma'am and the evidence is misleading and unreliable, and the best evidence remains ma'am and the parties' communications themselves. Number 4. The court must consider each defendant's subjective state of mind separately. In the interest of streamlining this case, defendants file a joint response here, but they object to any suggestion that they share a state of mind. Actual malice is based on an individual defendant's subjective state of mind, and one defendant's intent cannot just be imputed to another. Accordingly, Netflix objects to Colborn conflating its state of mind with the producer defendants and vice versa. The producer defendants object to any suggestion that notes from Netflix reflect the producer defendant's state of mind, and vice versa. Defendants also object to any efforts to conflate the personal opinions of an employee who lacked decision-making authority with the defendant's state of mind. In particular, defendants object to any mischaracterization of Mary Manhart as defendant's, Chrome's editor, MAM's primary editor, MAM's creator, or Chrome's creative team, or any efforts to conflate her personal opinions with any defendant's state of mind. Moira Demos was the lead editor of the series, and Manhart's testimony details her project-based editing role. noting that by the time she joined the team, films that were 1 through 4, I guess, were in very good shape. They were very solid, rough cuts, very solid. And responding to questions about being, quote unquote, consulting editor on episodes 5 through 9, quote, they were really Moira's, and I did almost nothing on them except watch them and give notes, which is what a consulting editor does, end quote. Manhard's credits reflect her role, including consulting editor for episodes 5 to 9, which includes the trial episodes. Additional editor for episodes 2 to 4, co-editor for episode 1, and editor for episode 10. In comparison, Demos received editor credit for all 10 episodes and shared editor credit for only one episode, episode 10. See Mem credits. Manhart worked under Demos and McCarty's instruction and supervision. Manhard's opinions do not reflect the subjective state of mind of either the producer defendants or Netflix.
I think she does. She's doing a really good job of pointing out how Colborn's lawyers have mischaracterized and mislabeled a lot of shit in their filings.
All of the notes between them, yeah, absolutely. He just thinks they were just out to get him.
Well, it's really and it's really from a lawyer standpoint. To me, it goes back to this: what are you doing when you're talking to the trial judge, and he can read for himself, but you're intentionally trying to mislead him by mislabeling what these various people have done. It's terrible.
They're just trying to make it so nefarious, and
yeah.
It's just ridiculous. And I think it's got to be just crystal clear for this judge to see, what they're doing. I don't know.
I would hope. I would hope, that he reads it as it really is and what they've tried to do. And again, because we've read so much, and we knew that there was some manipulation going on. I had no idea that they had taken this in their filings and mislabeled and mischaracterized it to this degree, but clearly they have. Lita wouldn't say that if they hadn't.
Right. Wow.
Before we get started again, a couple more people have joined us in chat. We've got Kelly McCallion, who's joined us. Hi, Kelly. We've got Andy B, who's joined us, and he says, "Hey, what's going on here? Who told you that you could have another one when I haven't even finished last night's open mic yet? You all are well shady."
Andy. Rascal.
And we've got Ian Rose as well, who's joined us. So hello and welcome. And Anthony House as well. And Anthony is asking Susan, read it like Kratz would read it, Susan, and that creepy sleazy voice he has.
Yeah.
Sorry, this isn't Kratz talking.
Yeah. This is the most excellent Lita Walker. She is. I'm so impressed with the. You think about, a lot of times you think about lawyers, defending a big corporation, but she does such a. To me, she does such a good job. She doesn't put stuff in that's not necessary to try to gain favor with the judge. Her writing is so well done to me. It's fair. It's almost, I don't know of any mistakes that they've made. I'm not saying they haven't made any, but I haven't caught any. But her writing is snarky. There was one we read last night that, she's pretty snarky, but as necessary in this adversarial process. So I don't know. I really appreciate what she's done and her ability as a lawyer. She's just fantastic.
Yeah,
I agree.
T1 and Mary B. Hello, Mary B. Hello, T1, who's just joined us. Nice to have you here.
No, T, we're moving on. We're on document whatever the hell it is, 346, I think, something like that, 347, somewhere around in there.
So.
Yeah, and this one's pretty long, so we'll read of it. I mean, if we end up having to, just read through it and, take another time, hey, that's what we'll do. Because, again, this is what Ludwig is going to read and make his decisions
And
on.
it's interesting because as a lay person, you know, for anybody that's not a lawyer, I don't think would have known this, that they
No.
snuck this addendum in and tried to get away with something that's not proper.
Correct. I would have had no idea.
Yeah.
Alrighty. Yeah, you continue on whenever you're ready, Susan. Or if you want to hand it off. And again, you hand it off if you're ready. You want to do something else. You know, do you take a break?
I'll keep going for a little bit, Jack.
Sure.
Okay, we're on number 5.
Yeah.
Beyond state of mind, the court should resist Colborn's attempts to conflate one defendant's conduct with another's in this litigation and the events giving rise to it. Hold on just a minute. I was reading off the YouTube. Oh, that was just the title. Okay. From the beginning of this case, in the original complaints, the subsequent amended complaints, and throughout the discovery process, Colborn has demonstrated an unwillingness to recognize that while Chrome Media, Laura Riccardi, and Moira Demos are part of a common enterprise, Netflix is a distinct corporate entity that had a specific role in the creation and release of MAM. In his most recent filings, this manifests in the form of accusing quote-unquote defendants in the collective of supposedly refusing to produce certain evidence, including assembled cuts. Netflix has been very clear for many months that it never received, possessed, or even watched any raw footage or other source material, and that it did not retain any cut of any episode except the final cut. Colborn has no evidence to the contrary. Netflix never had possession of such video evidence, and it certainly has not, quote-unquote, refused to produce it. Nor did the producer defendants refuse to produce evidence. As explained in depth in July and August of 2022 correspondence, the producer defendants produced everything they agreed to and disclosed what materials they no longer possessed. Colborn never moved to compel further discovery. Crucially, all the raw footage of Colborn was produced. The producer defendants produced all raw footage from all camera feeds of Colborn testifying at Avery's trial. Defendants' joint responses to plaintiff's additional proposed finding of fact, docket 325. Number 1. Oh, I'm going to read the footnote here. For the court's ease of reference and convenience, defendants have followed the numerical sequence of Colborn's CAPFF. However, they note that there are actually 95 facts rather than 94 as numbered by Colborn. This is so because number 48 was intentionally left blank, but there are 2 sets of number 53 and 2 sets of number 74. Additionally, several of Colborn's facts are compound and should have been separately numbered statements, bringing the total of additional proposed facts well beyond the 100 additional facts permitted by Civil Local Rule 56. Defendants object to all facts over 100.
Which they do, and they should.
Yeah. Number 1. This case arises out of the Netflix series Making a Murderer. Defendants Chrome Media, Chrome, and its principals, Laura and Moira, take significant credit for the content of MAM, contending that they are producers of the series. However, Netflix was also undeniably heavily involved in the creative development of each and every episode, as described further below. Netflix approved the final cuts of all MAM episodes. Netflix aimed to craft the series from quote-unquote a marketing perspective and also from an awards qualifying perspective. Response. Defendants object to this proposed finding of fact as compound, joining as one proposed fact at least 4 distinct proposed facts, which should have been separately enumerated in violation of the local law. Responding to each subpart. 1A. This case arises out of the Netflix series Making a Murderer. Defendants, Chrome Media and its principals, Laura and Moira, take significant credit for the contents of MAM, contending that they are producers of the series. Undisputed. Number 2. However, Netflix was undeniably heavily involved in the creative development of each and every episode. Disputed as attorney argument unsupported by record evidence, vague and misleading. Defendants respond to Colborn's specific proposed facts regarding Netflix involvement in MAM as they arise below. 1C is undisputed. I'm not going to read it. 1D. Netflix aimed to craft the series from a marketing perspective and also from an awards qualifying perspective. This allegation goes only to Netflix's state of mind, and Netflix is thus in the best position to answer it. Undisputed that the document cited contains the quotations a marketing perspective and awards qualifying perspective. Disputed as misleading, removed from its context, and immaterial. The document speaks for itself and makes clear that these comments were made by Netflix in reference to whether the defendants could afford to push the overall start date of MAM or else restructure several episodes to release the final episodes of the series at a later date. Do you think these all need to be?
I mean, if there's a disputed one, then, maybe read it, but the undisputed ones, no, not really. I mean, we can scan them.
Yeah, maybe just read the responses. I don't know.
Yeah. Yeah, I think that's probably, we can read maybe the header of what's of each one and then just read the response instead of having to read the entirety of all.
Yeah. Mm-hmm.
Yeah, just read the response to this one.
To number 2.
Yeah.
Defendants object to this proposed finding of fact as compound, joining as one proposed fact at least 3 distinct proposed facts, which should have been separately enumerated in violation of the civil local rule. Responding to each subpart.
Yeah, just to clarify, this can get, and I can see it now, and I'm sure you can too, Susan, the reason you said that, this can get really tedious, really tedious. And, we don't want to bore people out to the, want to start taking a gun in their hand.
I don't know that it's really necessary. We know how ridiculous all Andy's claims are. And they're coming back with why they're ridiculous, basically. But we have read a lot of, the same line of thought kind of thing,
Yes, the same vein. This mindset.
Same vein. Thank you. Yeah.
Yeah. And they're, again, I think that between the various lawyers for Colborn, they've piled on and then they've taken the additional step, as she's pointed out, of violating this local rule and piling on even more, and even going so far as mislabeling and mischaracterizing these various people that are Netflix, and trying to lump them in as in Maura and Laura are the same entity, and they're not. They're completely not, and they really tried hard to do that. So, I tend to agree with you. I think maybe we could just
skip over all of this. Yeah.
Yeah. I'm like you. It's going to get really tedious, and if when the document's going to be available, if someone wants to read through all of it. I'm going to quickly flip through the pages here, and if there's something that jumps out, we're going to read it. But otherwise, we're going to move on. So let's start where we're at right. Let's start where we're at right now, and I'll just move forward here. Respond. You can see how tedious this is going to get. There's some undisputed parts, and then they disputed as misleading and removed from the context the entire notes. You know what? Let me make this a little simpler for this document here. I'm going to make it smaller. That way we can see more of it. You see how tedious this is going to get. Judge Lloyd is probably going to. He's probably going to sit there. Even take here's one with Kratz and Colborn exchange. It looks like probably from the trial, which is really at the heart of all of this. That's or a big part of the heart of this case is what he's saying. Colborn's claiming that he was mischaracterized at trial simply because they didn't have the entirety of the trial recorded, and it's unfortunate, but hey, they did the best they could and still carried the same message.
Number 6 is kind of interesting.
What pages?
Let's see, I'm on page 16. Or wait, it might start on 15.
Oh, I'm way the hell in front of you.
This part is just kind of interesting, where Andy kind of took a piece out of some notes that they were writing. That's actually on page 18. And mischaracterizes the evidence, because this quote comes from an entirely different set of quotes. From which this quotation is plucked in context.
Hit page 18.
Mm-hmm. 6D, page 17 at the bottom.
Okay, yeah, quote, we want to feel the swells of hope, the range of influence, the horror of defenseless, end quote. Netflix continued, disputed as misleading, removed from the context of the entire, not quote unquote, of and concerning Colborn and immaterial. See general objections. Colborn's use of Netflix continued mischaracterizes the evidence because this quote comes from an entirely different set of notes. Oh my God. Wow. He's not going to, I'm telling you, Ludwig is not going to like that at all. He's not going to like that.
The rest of the note from which this quotation is plucked in context reads, status. The series is amazing. It is a major accomplishment to lay out such a complex case in such a clear and suspenseful way. Some structural and pacing challenges may not support full audience engagement for such a long view that at times gets very granular. Goals. Identify final overall series structure which supports the most impactful, compelling, and revelatory storytelling, including ideal number of episodes, 9 to 10, ideal length of episodes, recommending 50 minutes, no greater than 60, best opens and closes, red herrings, expand the emotional range for the viewer throughout the series. We want to feel the swells of hope, the rage of injustice, the horror of the defenseless. Viewers across the globe should be in tears and shouting at their screens throughout.
And see, that is completely, oh my God. Wow.
Yeah. Jeez.
Yeah, what if they learned that little trick of taking something completely out of context? I wonder
Yeah.
who would do.
Uh-huh. All they took was the very last sentence of that entire.
Yep. Instead of explaining everything in context, and it does matter. Context is everything. We found that out in dealing with the many guilters that we've dealt with over the years, that they love to take stuff out of context and try to make it into something that it's not.
Yeah, exactly. But there's a lot of that going about all over the internet right now, Jack.
Sure.
You know,
Sure.
I mean, there's a lot of cherry picking jobs going about, because that's what they like to do. They like to cherry pick. They like to take a certain sentence or a certain quote or a certain reaction, look, phrase is immaterial, and they twist it to fit their narrative because they think it sounds better. When it doesn't, it just makes them sound pathetic, ridiculous, in some cases vile, you know what I mean? And I am seeing a lot of people cherry picking at things.
And when they get caught, they just want to ignore it, or they run, delete their account and move on, create another.
Or see that.
Yeah, that too. Yeah, I had one guilter, and he's still around. Actually, he was the worst. He would say something, maybe a comment or whatever to something, and say something that was not true, and then you call him on it. He would go, and this is on Reddit. He'd go back and edit his comment. Now with Reddit, when you do an edit you can edit your comment or your post. You do see it, but Reddit requires you to explain why you edited your comment. That's just the way it's been. That's the way it's been since, I won't say the beginning, but I mean, I got on Reddit probably in 2007, 2008. That's just Reddit. You just explain what you've done. Correction, clarification, spelling error, whatever. Or you can do an ETA. That's where you add more to your comment, edit to add. And what he would do, he'd get caught. Some people would call him on it. He'd go back and edit his comment and change it. So what I started doing with this guy, I would quote his entire comment, and once you quote it in and include it into your comment, it's there. He can't change that at all. He was the worst.
So, Jack, I mean, I was going backwards and forth with somebody on Twitter the other day, and I'm sorry, this is nothing to do with what we're reading, but it's an explanation of the cherry picking that I'm talking about. And some people might roll their eyes, but it's about Meghan. And somebody had put up a post trying to make it seedy or demeaning or anything like that, because when Meghan was younger, she worked on yachts. So she was a yacht girl. So I then posted the exact same thing about Kate, that she was a yacht girl as well when she was younger, who worked on yachts and everything like that. So they came back with, but Kate was working. Meghan was only doing it for entertainment. But my point is that the two of them were yacht girls. So you can't diss one person for being one thing when the other person done exactly the same thing, but they turn it and make it seedy. You know what I mean?
Sure.
And then when you prove them wrong like that, because I posted and it's Kate standing with her hands on the wheel on a yacht, you know what I mean? So look, it says she was a yacht girl. They delete your post, or they delete your comment, or they stop you from posting on their post. You know what I mean?
They block.
Yeah. And it's like, my God, if you can't dish it out, if you can dish it out, but you can't take it, then you shouldn't be cherry picking things like that. Because as I always say, what's good for the goose is good for the gander.
Sure.
You know what I mean? And they've done a lot of cherry picking when it comes to this case, especially with Colborn, cherry picking different bits. and it's bits that he's not even supposed to have watched that he's cherry picking from. You know, it's bloody ridiculous.
Yeah, this footnote right here, and I'm just going to read it. Colborn also cites and I guess this is an exhibit at 2187, and as an initial matter, these are two separate documents, unrelated to one another, and which happen to have sequential Bates numbers. Additionally, in this next one, 2188, it's about the MAM trailer, which was never put at issue in any of Colborn's 3 complaints, and therefore is not relevant to the case. Colborn's reliance on 2186 is similarly misplaced, as the email thread is about finding an additional editor to join the producer defendants. Editing team does not, let me read that again, is about finding an additional editor to join the producer defendants editing team. Does not contain the quotes above and is not about, nor does it even reference Colborn. Wow. Man, I tell you, that's some really shady lawyering, dude. I'm telling you. And I said the one document we read a few weeks ago, it was so terrible. It was the one that Burnett had penned. It was just really bad lawyering. And I think
just imagine the time and energy it took to pick all this stuff out and re-reference and to make all this shit up. Oh my God, what a waste of frickin' time.
It is. It's a huge waste of time. Anyway, I think we should just leave it here, and for anyone that wants to read it, it'll be in the library.
Yeah.
And they can read it. But I think it's just going to get so tedious. It's going to get really tedious. So let's move on to 347. What do you say? And this is a document. Let me make this. This is from Rockstead to Ludwig. And let me make this a little bit bigger, and I'll read it. Doesn't look like we got it's a 1-page document. Okay, dear Judge Ludwig, it has come to our attention while preparing our reply brief in the above matter that plaintiff's response brief opposing defendant's motions for summary judgment inadvertently included a citation to a case that was intended to have been removed because it was later reversed based on the facts in that case. We respectfully
oh my God.
We respectfully request that the court and counsel disregard that reference in response brief, and it gives a citation there. Our sincere apologies to the court and counsel for the oversight. April. And this is not
that was recent.
Yeah.
December 9th, maybe.
Probably.
Yeah.
Moving on to 348. And this is a 4-page document, looks like. And this, this is plaintiff's Colborn's response to defendant's Netflix additional proposed finding of fact. Alice, do you feel up to reading this?
Yeah, sure.
Okay, you start whenever you're ready. It's only 4 pages.
Plaintiff Andrew L. Colborn's response to defendant's Netflix Inc.'s additional proposed findings of fact. Plaintiff Andrew L. Colborn, by his attorneys, the law firm of Conway, Olgins, Dassey, and Jerry, responds to defendant Netflix Inc.'s additional proposed findings of facts as follows. Netflix's additional proposed finding of facts. Number 1, MAM used graphical elements to enhance the clarity and factual accuracy of the series for viewers, especially because Avery's story spans several decades and involved key players. See docket 271, 99-103. In episode 2, one such graphic, which included the photographs of several individuals, including Colborn, Link, and Peterson, was used to orient viewers. Episode 2 at 2026 to 2034. Response 1. Admit that MAM used graphics, but denied defendant's stated motive in using the graphics was to provide viewers clarity and factual accuracy, as the graphic cited as show to how Colborn didn't make a report to superior officers on the jail call, at which time he was only a corrections officer and had no authority to investigate. Number 2. Immediately following the partial quotation of Avery's counsel, Butin referenced in Colborn's proposed fact number 42, episode 4, also includes Butin stating, "So we looked around and one guy's name just kept coming up over and over and over every place we looked at crucial moments, and that was Lieutenant James Link. Link is the guy who finds the key in the bedroom on the 7th entry at supposedly in plain view. Link is deposed just 3 weeks before this Hallback disappearance. And then, most peculiar of all, is when we looked in Stephen's old 1985 case files in the clerk's office, some items from that court file ultimately proved to exonerate Stephen. Interestingly enough, the transmittal form that goes with the evidence in 2002 to the crime lab is filled out by none other than, at that time, Detective Sergeant James Link. See episode 4. Response 2. Admit the quote is accurate as to what is portrayed in MAM, but denies that any of Butin's statements are admissible for the truth of the matter asserted. Number 3. Episode
For
7.
fuck's sake, they tried to put the whole series as truth of the matter.
Yes.
Yep.
It's crazy.
Episode 7 includes a scene in which Avery's attorneys, Strang and Butin, are strategizing over the theory of the defence and preparing for the forthcoming witnesses' examinations in Avery's criminal trial for the murder of Hallback. After the lengthy exchange in Colborn's proposed fact number 50, Strang states, quote, "Yeah, I'll connect that," unquote, referring to a line of cross-examination Strang would pursue in court. See episode 7 at 10:45 to 12:05. The rest of the episode shows those series of cross-examinations. See docket 271. Response number 3. Admit that Strang states, quote, "Yeah, I'll connect that," unquote, as referenced above, but deny the rest of the episode shows those series of cross-examinations as other things are mentioned in the reset of the episode. Number 4. The note from the Netflix creative team about, quote, "bad guy theme," unquote, music from which Colborn selectively quotes in proposed fact number 73 reads in full, quote, 4200, learning that Tom Fassbender is calling Scott Tadich to convince Barb, make Brendan take a plea, perfect moment for, quote unquote, "bad guy theme." See docket 286, exhibit 9. It makes no mention or implication towards Colborn. Response number 4. Admit that the quote is correct and admit that Colborn's name is not mentioned on Netflix Code 2037, but deny the accusation as cops and prosecution are mentioned, and Mr. Colborn is repeatedly identified throughout the series as one of the Manitowoc County Sheriff's Department's officers alleged to have a role in, quote, planting evidence, unquote, against
Well, they're
Avery.
sure they're making
for
a
fuck's sake.
they're making a huge leap right there. Oh my God.
Oh my God. Jesus. Just because they said cops and prosecution are mentioned.
Yeah.
Oh, jeez.
Go ahead.
Number 5. The note from the Netflix creative team from which Colborn selectively quotes proposed fact number 74 reads in full, quote, 21-23, is there anything we can use or show to clarify whether or not the cops had a warrant to search his property, and allude to the fact that they may have planted something when they were there without permission, unquote. See docket 286, exhibit 11. Response: admit the below appears in Netflix Cole 1940. 21-23. Is there anything we can use or show to clarify whether or not the cops had a warrant to search his property, and allude to the fact that they may have planted something when they were there without permission? Number 6. The email from filmmaker Moira Demos regarding the trailer for Ma'am referenced in Colborn's proposed fact number 78 was not sent to any of the members of Netflix creative team who worked on the production of Ma'am: Lisa Nishimura, Adam Del Deo, Ben Kotner, or Marjon Javadi, through whom Colborn must prove actual malice by clear and convincing evidence. See docket 286, exhibit 14. Response number 6. Deny, as Peter Stone from Netflix confirmed and replied, quote, we are using the quote unquote squirmy shot from the locked cut, unquote. See docket 303 through 7 from 395. Plaintiff also notes this document was unexplainable, not produced by Netflix in discovery. Plaintiff also objects to the proposed fact as in fact including legal argument and proposed conclusions, and as ignoring the fact that the quote squirmy shot, unquote, may be considered evidence of Chrome's and Netflix's actual malice with respect to the series as a whole.
Jesus
Oh,
Christ.
for fuck's sake. Who is this? Who is this? What's his
Lawyer?
name? Peter Stone.
Yeah, we read one email last night, and I think it's the only email that I remember from this Stone. He's connected to Netflix in some capacity. I don't know what his position is, but
yeah. And evidently, they got this email from him. I'm not sure who he is, but they were talking about Netflix's creative team and mentioned everybody that was on the creative team. But I don't know who this Peter Stone is. Yeah,
he's some executive or somebody connected with. I think he's one of the first ones actually that back in 2013 when Laura and Maura were they were connected to I can't remember her name, Eileen or something. It was in an email, some emails we read last night, and this guy was he got this email from her, this creative editor that Laura and Maura were working with, and basically was inquiring if they were interested in the series. She had included some a link they had put up on some server, some of the rough cuts of episodes 1 and 2, and he replied, "Yeah, they were very interested. They wanted to sit down and talk." There was a chain of it was an email chain. So he was somebody. Yeah, he was somebody that initially was in contact with them. That's who he. So I don't know his exact title. I don't remember.
And they're saying this document was unexplainably not produced by Netflix and Discovery. I'm sure that's probably the only role that guy had, maybe.
Well, from what we can tell, and from what I've seen, I've never seen his name before. So it was like
Right.
he made the introductions to the rest of the proper people at Netflix,
Right.
and then from that point was uninvolved.
It wouldn't.
And they're trying to call this
hello.
actual malice. I mean,
Yeah.
come on. Is that Christina?
Can you hear me?
Yep.
I do.
Hi, y'all.
Hi.
It wouldn't surprise me to find out that he wasn't like a representative from Netflix, like at Cannes or Sundance or wherever the docu-series was first pitched. He
Yeah, I mean, you're probably
saw
right.
the
Yeah.
original,
hmm
and said, "Hey, I think this is a story that would do well for us and it deserves to be told." And that was probably, he probably had very limited beyond that. And so they're trying to use that little bit of interaction to make him to tie it to Netflix. That's a desperation, if accurate, if that's true, because he's never mentioned.
Yeah.
Yeah,
Did
I
Probably
think
right about that.
depose
Yeah.
him? Did they depose him? Do you know?
no, he wasn't deposed.
Yeah.
I think he just made some initial introductions after he saw the rough cuts and really thought, hell, this is a great story. You know, I don't remember
Yeah.
I don't remember which document or attachment it's on, but we did look at it last night, and it's not that much, I think, and after that, he was out of the picture.
So they
it
must have
says
hit
a
him
lot.
up for emails.
It
I
says
say-
a lot that he wasn't deposed by Colborn, doesn't it?
Yeah, he's uninvolved. I mean,
Yeah.
I think, and also part of the reason we got this is because the document, I'm pretty sure that was Lita that wrote it, whatever brief it was. She was basically pointing out that they had produced like a lot of emails and communication, whereas Colborn had only really produced about 5 or 6 emails from back in that time frame and had not produced anything else. And they think there was more. That was basically what they were alluding to. And I think that's the reason we got this particular one. They've produced a ton of emails that Netflix has. So
Yeah, for fuck's sake, Colborn was the one that created the squirmy shot. I mean,
that's right.
Yeah.
he
Yeah.
did it. They didn't. And they're trying to say it proves actual malice
Hey, you want to say
by
hello
Chrome
to?
and Netflix. Give me a
Yep.
break. Sorry.
I want to say hello to Dr. Silkman, and it looks like we have Yoga for the Ages has joined, and Mary. Yeah, Mary B. Yep, I see her name. Hey, thanks for coming in, folks. Really appreciate it. All right, Alice, you can continue on. We're about done with this document.
Okay, number 7. At his deposition in this case, Colborn testified that to accept his denial at Avery's murder trial that he planted evidence, quote, "You would have to trust that I was telling the truth under oath," unquote, but that, quote, "I like to think that my testimony and when I say something, people understand that I'm under oath and I'm saying the truth," unquote. Second deal of Lita Walker, and it's giving you the numbers there. Response number 7. Admit that Colborn made the statements quoted above in deposition testimony, but the statements are not produced in full context and deny that they are complete.
So,
Number 8. In response to a question about whether he could, quote, "understand how someone who wasn't there," unquote, when he searched Avery's property, quote, "might have some uncertainty about," unquote, his explanation of how he and others found the evidence that led to Avery's conviction for Hallback's murder. Colborn testified that, quote, I don't have an instinctive distrust of law enforcement, unquote. Response number 8. Admit that Colborn made the statements quoted above in deposition testimony, but the statements are not produced in full context, and deny that they are complete. Dated this 9th day of December, 2022.
April Barker and co-counsel George Burnett. Yes, they're ones to talk about anything being out of context. Let me tell you what we've seen so far tonight. Okay, yeah, that was pretty comical overall. All right,
No
let's move
shit,
on.
Sherlock. Talk about out of context. Good
Yeah.
God.
Yeah. Cherry picking. Fucking
Yeah,
cherry picking. Must be
move
the
on
new
to-
craze lately because everybody seems to want to cherry pick what they want.
Let's move on to
Case 10
document.
says squirmy shot mixed with danger music. Bad combination. Oh,
Let's move on to 349. And this is we're going to have a attachment. I don't have it pulled up yet, but I'll pull up here in a minute. This is a declaration of Kevin. And Susan, you up for reading this one?
sure. This is 349.
It is.
Okay. I'll read it off of YouTube. I don't have it. I, Kevin L. Vick, under penalty of perjury and subject to 28 U.S.C. 1746, subsection, declare as follows. Number 1, I am one of the attorneys for defendants Laura Riccardi, Maury Demos, and Crow Media, collectively the producer defendants in the above captioned action. I have personal knowledge of the matter set forth in this declaration unless otherwise stated. I make this declaration in support of the producer defendant's reply in support of motion for summary judgment. Number 2, attached as Exhibit 1 is a true and correct copy of my discovery correspondence to Plaintiff's Counsel Christina Summers, dated August 10, 2022. This letter is referenced in the August 23, 2022 and August 26, 2022 letters that plaintiff filed with his opposition to dockets 317-2 and 317-3 and provides remaining context on the producer defendant's document production and discovery responses. I declare under penalty of perjury that the foregoing is true and correct.
Well, this is a December 9th. This is December 9th. So you guys talk amongst yourselves for a moment, and I will close this, and I'll open up some more documents. That's the last one I have loaded. And I'll also put them.
How much more ridiculousness can this get, you know? And if we are finding it tedious and boring and repetitive, imagine what the judge is thinking. You know what I mean? Reading this, he'll be sitting there with the horns in the head. You know what I mean? Giving it, oh my God, is this for fucking real?
I hope he just watches Ma'am and figures it all out and says, there's no malice here.
No.
I think that if he's truly trying to be just, he has to watch Making a Murderer.
Yeah.
In order to.
Of course.
I don't think he can rely on either side's supposed facts in a case that is covering a wrongful conviction or a possible wrongful conviction where a definite wrongful conviction has occurred, right? Because there's just too many, that's just evidence right there that lawyers can be wrong even if it's unintentional. So it's going to be interesting for sure.
Hell, it's going to take him a year to read all this shit.
Yeah, wow. I'm still not caught up. I don't know about y'all. I haven't read all of this stuff submitted this case.
There's so much.
Yeah.
Saying, I wonder who's paying for all this. Aye, so do we. We're
Yeah.
wondering who's paying for it all, and all, especially on Bawheat's side, Colborn's side. And Case 10 says, has Ludwig ever said he's watched, ma'am? I don't think so.
Mm-mm. Yoga for the Ageless said maybe the judge will be joining us in chat after this case. Yeah, that would be great. That would say a lot about his morals if he did.
Catnet says, how bonkers is it that the judge might have to watch, ma'am, but the one suing has not and refuses to do so? Yeah. He says he's watched, what, 30 minutes to 40 minutes, if that, but yet he's gone on about episodes 8 and 7 and 10 and 4 and 5. You know, it's like, well, make up your mind. They were 50 minutes an episode, so that's an hour an episode. So, how many have you actually watched? You know what I mean? None.
All right, I've got everything loaded that we've received so far to date. I don't know if we can get through it all, but we'll try. And this is the one. This is the exhibit. This is 349-1. This is the attachment, and it talks about this is the emails he had with Christina Summer. Let me take a look here. This is a 6-page document. And this is the first one. Looks like this is going to go in order. Let me make this a little bit. There we go. Okay.
Yoga, hang on a sec, Jack. Yoga for the Ageless said, someone in Reddit says they found proof that the money was coming from the makers of Cam. I asked for a source.
Yeah, you need a source for that because.
Yeah.
You know, I'm glad that y'all said something. If let's role play here. If I was an officer involved in a case where I knew that I had rightfully convicted someone, okay, no matter how ugly the peripheral stuff is, if I knew I had done the job right, and there was a documentary made that tried to say otherwise, I think that I would be compelled to sit down and watch every episode, if for no other reason than to take detailed, specific notes about what they got wrong.
How can you not?
Yeah. And
he had someone do that for him.
His lawyers.
That's not good enough. No. That other chick, right?
BS, yeah.
Yeah, but wouldn't you be like, think about it. If honestly, like if somebody made a 10-part docuseries about you saying that you framed someone and you know you didn't, what would be your gut reaction? It would be to watch it to see what they did wrong.
Sure.
Yeah, see what they were saying. Yeah, absolutely.
Yeah. And the fact that no one has done that, and all we have are these sorts of complaints. This is the gist of their "we were defamed" argument. So it speaks volumes. I don't know why that just now clicked.
Yeah, no.
But
to me,
to answer. Yeah. Go ahead, Alice.
To me, in my opinion, that's a load of bollocks. Him saying that he has not watched it is a load of bollocks. The rest of them saying that they've not watched it is a load of bollocks. Because I guarantee you, they've all sat and watched it. And because they've been made to look like arseholes and the corrupt dickheads and tossers that they are, that they're all saying, oh no, we've not watched it, we're not going to watch it, don't need to watch it, we were there, we know what happened, you know what I mean? So to me, that is all a load of shit. They have all sat and watched it. And as I say,
Yeah.
it's because they've been caught out and they've looked like tossers. They're all saying, oh, I've not watched it, and I'm not going to watch it. Right.
Yeah, Mary B, just to explain, he says he's not watched it. This is what we know. And he said up until this year, and it was right before his depositions in July, what Colborn has testified to in his responses that he watched roughly 30 minutes of just a few episodes of MAM, specific, whatever. And then prior to his depositions, he was shown, and during the depositions, he was shown more. And that increased his time of watching MAM to roughly an hour and 15 minutes to an hour and a half of at least the first 10 episodes. So that's, according to him, all he's watched. And that he has his responses in his depositions was that he had lawyers to do that, which I'm with Alice. I don't believe it for a second. I don't.
But he also reserved the right to watch it in the future.
Yeah.
Something like that.
Yeah, something like that.
Yeah. I mean, you're suing these people for defamation, but you haven't watched it. So you're suing people on hearsay who have came back to you with air quotes, you've no watched it, and says, oh, Andy, oh man, you should see what they said about you. They said you're a corrupt cop and everything like that. Oh my God, you need to sue. So he's just decided to sue. I'm right.
Well, you know, the way I look at it is that he started getting all these calls and emails and, you know, threats and all that kind of thing. And that is the reason that he felt that, you know, he was wronged.
Yeah,
it was in response to all of this,
being defamed. Yeah, he was
vitriol
defamed.
that he got.
Yeah.
And so he felt like he didn't really need to watch it. He knew what the, you know, the outcome was, and what the response was from the public.
Yeah, and then built up all these other things that he had to walk away from. That you know caused this. MAM caused all these problems in his life.
And lied about a bunch of stuff, basically.
Basically,
Yeah.
Christina.
About his divorce, etc., and his health and all that.
But I say, if I know I didn't do anything wrong, I would be curious as to why there was such an overwhelming reaction to me doing the right thing. And I would have to see for myself what they did to make me look like I was doing anything but the right thing. And the fact that he is claiming not to have watched it so that can play dumb.
It's not reasonable.
More about, no, it doesn't. It says more about the about his guilt than his innocence, in my opinion.
Yeah, Matt says maybe they should play it in court, and you know if it survives summary judgment, that could potentially happen. And then Katniss says AC refusing to watch it shows his character and is going to let his ego and stubbornness hinder in his own case. Yeah, I can't disagree with that, Kat, at all.
And Doc says if you take into account how Andy writes his reports, he'll watch MAM in 2035.
Yeah, probably from the nursing home, you know, when he's carrying around his oxygen tank, you know. That's about. Anyway, all right, I'm going to read this letter here.
Jack, I'm just it says in response. Are you sure that's the first one?
It's dated August 10th.
Okay.
The other one's dated, I think, the 18th. It's after. Yeah, see, it's in response to your letter dated July 15th.
Yeah.
Yep. All right. He says, Dear Ms. Summers, I write in response to your letter dated July 15, 2022, regarding alleged deficiencies in the response of Laura Riccardi, Maura Demos, and Chrome Media, collectively the producer defendants, to certain requests for production from we'll get to the footnote where it's down here. Okay. Before turning to the substance of your letter, I must first address the untimeliness of plaintiff's complaints regarding any alleged deficiencies. The producer defendant's responses at issue in your letter date from mid-July 2021, more than 1 year ago, through early April 2022, many months ago. Besides the passage of time, the deadline for fact discovery in this case came and went on April 8th, 2022. Indeed, even the deadline for depositions for all deponents except plaintiff was May 20th, 2022, nearly 2 months before you sent your letter. Moreover, the parties met and conferred regarding respective alleged discovery deficiencies months ago in April and early May of 2022, following correspondence sent by the various defendants in March 2022. Then we heard nothing on the subject from plaintiff until your July 15, 2022 letter. And I'll read the footnote. Netflix attorney Alita Walker on July 29, 2022 letter to you set forth a full timeline of the events at issue regarding the meet and confer discussions that seemingly had concluded months ago. Rather than repeat what Ms. Walker notes, there, I refer to the timeline here. And then continuing with the letter, the time for raising complaints about parties' responses to written discovery has long since passed. Indeed, the deadline for expert disclosures is less than a month away for summary judgment motions is less than 6 weeks. It is unfair to expect the producer defendants and their counsel to divert their time and attention from such matters to address issues related to fact discovery at this belated juncture. We have strived to be reasonable and accommodating with respect to discovery deadlines where there was good reason. For example, we agreed to let plaintiffs depose Lisa Dennis and Mary Manhart after the May 20th, 22 deadline, when those deponents had health issues and precluded earlier depositions, and we did not attempt to seize some litigation advantage based on the fact that plaintiff had waited to notice their depositions until the final week for depositions. However, there is no similar good cause for plaintiff waiting until mid-July 2022 to raise complaints about perceived deficiencies in the producer defendant's responses to written discovery, some of which date back to more than 1 year. This is particularly true considering the enormous burden that plaintiff's written discovery requests placed on the producer defendants in this action. As reflected in your letter, plaintiffs served 7 sets of requests for documents on the producer defendants, including a final 7th set that was very broad and required producer defendants to effectively redo prior searches and even re-review documents in response thereto, in contrast to the normal procedure in discovery, where parties begin with more general requests and then send more targeted and a narrow follow-up request later. In response to plaintiff's 7 sets of requests for production, the producer defendants have produced nearly 35,000 pages of documents. Jesus Christ. The producer defendants have also produced approximately 15 hours and 20 minutes of raw footage of plaintiff's testimony at the Avery criminal trial in response to plaintiff's request for such raw footage. The producer defendants did so after the parties entered into an agreement whereby the producer defendants agreed to search for, process, and produce in usable form to plaintiff all raw footage they had of plaintiff testifying at that trial, in return for plaintiff withdrawing his other requests for footage. Even that compromise agreement was an enormous undertaking which required Ms. Riccardi and Ms. Demos to put aside their respective professional projects and to spend many dozens of hours each. Indeed, in total, Ms. Riccardi has personally spent more than 150 hours, and Ms. Demos has personally spent approximately 100 hours in connection with responding to plaintiff's 7 sets of requests for production. That is in addition to the many, many hundreds of hours that their attorneys have spent performing various tasks related to responding to plaintiff's sets of document requests, including reviewing and processing the many thousands of responsive documents and the 34,942 pages of responsive materials that the producer defendants produced to plaintiff in this act. In sum, the burden that the producer defendants have borne in this case in responding to plaintiff's request for production has been extraordinary, greatly exceeding the proportionality limitations in Federal Rule of Civil Procedure Rule 26. Yet the producer defendants have borne that burden along with the burdens associated with plaintiff's desire to take a full slate of the depositions in this case and to issue extraordinarily broad document subpoenas to many parties, including individuals who formerly worked for Chrome Media, which required producer defendants and their counsel to devote many additional hours performing a privileged review of tens of thousands of pages of documents produced by those individuals. Accordingly, the producer defendants believe that any complaints that the plaintiff has about their responses to the plaintiff's various sets of requests for production are not just without merit, but ultimately, and at this point, undue when viewed in the context at the discovery process to date. That said, I will respond below to the substance of your letter to further demonstrate the good faith approach that the producer defendants have taken throughout this case in responding to the plaintiff's request for production, and in the hopes of putting these matters to rest so that the parties can proceed with those aspects of the case that remain to be completed. Wow.
My God.
Yep.
The
Okay.
time put into this damn thing.
35,000 fucking pages, pardon my French. It's ridiculous. All right. I'm going to pause here, and if there's any comments, we can deal with them. Otherwise, I'm going to ask Susan to pick it up here if you want.
Sure. Plaintiff's third set of requests for production. Request number 1. Netflix already produced copies of the final executed license agreements in response to an identical request for production of the same material that plaintiff served on Netflix. The producer defendants do not have any additional documents besides those already produced by Netflix. Request number 2 and 3. All responsive documents within the scope of what the producer defendants agreed to produce have been produced to plaintiff, except for those that are listed on privilege logs previously served on plaintiff by the producer defendants on May 9, 2022. The producer defendants are not withholding additional documents beyond those that have previously been logged. There's a footnote there. And I'm reading off Netflix. Chat.
It's scrolling down.
I mean, not Netflix, you know what I mean. The producer defendants have not withheld documents in this case based on reporters' privilege shield laws. / Am I lagging? Are you going back up?
Going back.
Okay. Okay, the producer defendants have produced documents as they were kept in the ordinary course of business, and thus, like plaintiff did himself, they were not required to produce them with labeling to correspond to specific categories in plaintiff's requests. Finally, the parties, once again, including plaintiff, did not agree to exchange lists of search terms in this case as part of their ESI protocol, and they have not done so. Without going into detail, I can tell you that we did not merely search for Mr. Colborn's name, but included a host of potential misspellings and variations, and included in production documents that did not mention Mr. Colborn by name, but that referenced law enforcement, more generally with respect to portions of Making a Murderer that are put at issue by the second amended complaint. Footnote 3, paragraph 27 to 29, 33, oh, you're scrolling past it.
It'll come back.
33 to 40, 44 to 48, and Exhibits A and B to the second amended complaint set forth the portions of making a murder that are put at issue. Need to go back up.
Oh, I thought you finished that above part.
I don't think so. Where was footnote 3?
Oh, I'm sorry. Yeah, I see it now. Yeah, it's coming back.
And erring on the side of over-inclusion, we ultimately produced copies of the Season 1 notes that individuals at Netflix provided the producer defendants, even where such notes made no reference to Mr. Colborn or concerned portions of making a murder that were not put at issue by the SAC. Plaintiff's fifth set of requests for production. We have provided to plaintiff copies of all documents that we received from all parties to whom we issued document subpoenas in this case, including documents received from the Manitowoc County Sheriff's Office, the Calumet County Sheriff's Office, and the Wisconsin DOJ. To the extent, if any, there are documents therein responsive to plaintiff's fifth set of requests, all such documents would be contained in those productions. So they're saying we've already sent you all this stuff.
Absolutely.
Plaintiff's sixth set of requests for production. Request number 3. The producer defendants produced all the documents they agreed to produce, and then some, as the producer defendants produced the notes that they received from Netflix personnel regarding Season 1 of Making a Murderer, not just those described by Ms. Demos at 53 minutes into the reference video. The producer defendants have not withheld any additional documents beyond those reflected on the privilege logs they previously served on plaintiff in early May 2022. Request number 4, the producer defendants are not withholding quote-unquote rough cuts or sketches pursuant to objections or privileges, as explained in the producer defendant's response to request number 4. Quote, the producer defendants do not have any documents responsive to this request. A diligent search and reasonable inquiry have been made to comply with the request. However, the producer defendants did not archive or otherwise retain and do not possess any rough cuts, sketches, or prior versions of episodes of Making a Murderer, and only have final versions of episodes, end quote. Request number 5 and number 6, as with request number 3, the producer defendants produced all the materials they agreed to produce. The producer defendants have not withheld any additional documents beyond those reflected on the privilege logs they previously served on the plaintiff on May 9, 2022. The SI protocol in case and the producer defendant's obligations, searches, and productions with respect to materials exchanged by producer defendant and Netflix personnel. Plaintiff's seventh set of requests for production. Requests number 1 and 2. The producer defendants produced all the materials they agreed to produce, and they searched for and produced documents that included Colborn's and/or Lank's names, along with misspellings of names, along with many other materials. The producer defendants have not withheld any additional documents beyond those reflected on the privilege logs they previously served. Requests number 2 and 3 with respect to FRCP, the ESI protocol in case, and the producer defendant searches, productions, and obligations. Why are we going back through these requests? Request number 3 remains vague and ambiguous, notwithstanding your letter's citation to the definition of the word.
This is in connection with the 7th request, so they get renumbered again. So it's number 7. Yeah.
Your letter's citation to the definition of the word antagonist, along with other matters. Nonetheless, to avoid unnecessary disputes, we ran a search for the term antagonist in response to your letter and did not find any documents containing that term that related to either plaintiff or those portions of MAM produced at issue by the SAC. Requests numbers 4 and 5. The producer defendants produced all of the documents they agreed to produce. The producer defendants have not withheld any additional documents beyond those reflected on the privilege logs they previously served on plaintiff on May 9th. The ESI protocol and the producer defendant searches productions obligation. Request number 6, 7, 8, and 9. The PDs produced all the documents they agreed to produce. The PDs have not withheld any additional documents beyond those reflected on the privilege logs they previously served on plaintiff on May 9, 2022. Third set of requests, request number 2 and 3. Okay, request number 10. We provided to plaintiff copies of all documents that we received from all parties to whom we issued documents subpoenas in this case, including documents received from the Manitowoc County Sheriff's Office, Calumet County, and the Wisconsin DOJ. To the extent, if any, there are documents therein responsive to request number 10, all such documents would be contained in those productions. And finally, request number 12. The PDs produced all the documents they agreed to produce. The PDs have not withheld any additional documents beyond those reflected on the privilege logs they previously served on plaintiff on May 9, 2022.
There you go.
Producer defendants, searches, productions, and obligations.
This is his letter back on April 10th. And he copied Lito Walker and Ballasbar.
Oh my God, man, it's so fucking.
Yeah,
it really is. It's
they're asking for stuff they've already gotten. It's like,
yeah,
come on, you're holding back on us.
And well after the fact, discovery's done. It's been done.
Exactly. What the hell?
yeah. Well, does he think that they're Manitowoc County and everything like that like to withhold fucking documents? You know what I mean? They're no them, you know what I mean? They don't need to hide documents or prevent documents from being handed over, you fucking idiot.
Oh, man. Now I think we're coming up on just a bunch of cases that are cited, Jack. I think there's...
I haven't looked through these, so you might be right. This is document 350.
4 or 5 of them. Yeah.
Looks like this is...
We're unethical, so they must be unethical too.
Right.
Yeah, Justina, that's exactly what they try to say in there. And as Susan was reading that and they're going on about the defendants have produced all documents and everything like that, I was thinking, what? Just because you fuckers had documents and held them back and put them in a fucking safe and had a CD in somebody's book for fuck knows how many years, everything like that, you expect everybody else to be as shady as what you fucking were? No.
No.
Just to answer case 10's question, this case started December 17th, 2018. So it's 4 years, almost to the day.
Almost to the day, yep. And you're right, this looks like as I don't know why they included this Lexus citation, but it looks like as they're citing a bunch of case law. We're not going to...
Good. Yeah, no.
So it'll be in the library.
The next several ones are case law.
Yeah, 351. Yep, this is another. They pull up a case. This goes back to 2006. This is a 9-page document, so it is what it is. They've included it for whatever reason. 350.
Any lawyers in the crowd might want to read it, but I surely don't.
Hey, are you not? You're not hitting at Cherie, are you?
Not at all. I know she doesn't want to read them. Well, she might. I don't know. Lawyers might find it interesting.
For anybody
350
that wants to read them, actually read them and see what's happening, they'll be in the Foul Play library.
Yeah, this one's a Ranmo versus Rolling Stone LLC. This is a 2016 case. It's been cited and included. 354. Hey, we're back to a regular document, looks like. And this is a 2-page. Make this a little bigger here. Yeah, okay. This is a declaration of Deborah L. Mercer. State of Wisconsin, County of Brown. I understand the undersigned, being first duly sworn on oath, says, number one, I'm a licensed private detective contracted with a law firm of Conway, Olniak. And am I pronouncing that right, Susan? Olniak?
Oh, I would probably say Olena Jack, or I don't know.
Yeah, that sounds good. And Jerry L.C. Number two, in addition to the other items, plaintiff produced in discovery the following, and I'm not reading all these, but you can see them there. It's just a deposition of Colborn, evidence, 19 pages, Calumet County Sheriff Department Assistant Missing Person case, facts and subpoena for Avery trial, subpoena for Avery. I'm looking to see if there's anything interesting that we don't have. LTR to link, Joss and Colborn et al. Conference with the DA. Letter to link, Joss and Colborn. Reference.
Is that Joe's?
That's what I'm thinking.
Kind of,
I don't remember any letter.
Interesting.
Yeah, I don't know what that is off.
Conference with Kratz.
Subpoena dated 1/11/2007. I don't know of any subpoena. Well, maybe I don't know what that is. 750.
I don't know what that fax is either.
Fax to Remaker, evidence collection, letter to Rob Herman from Pagel, Manitowoc County time report. Okay, that's it. Okay, I know what the time. We know what that. We've got the time log. Overtime documents, recognition report, subpoena. We've got this Manitowoc County Sheriff summary, harassment voicemail, which we've heard about, but we don't.
Do we have the letter from Pagel to Herman?
You mean? I don't think so. If we do, I don't recall it.
Yeah, I don't either.
Here we go. I want to see this Colborn Depot testimony.
Like
that's number 9.
FOIAs.
Narrative dispatch. Don't know what that is.
That's probably when Colborn called in the plates.
I mean, I've got, a lot of people know I did a FOIA request for all FOIAs and their responses in a certain time frame, which was from January 1st, 2016 through June 30th, I think it was, 2021. And I got those. It's almost 1,100 pages that I got from Calumet County. I remember seeing her name, Deborah Bursick. She did request quite a bit of stuff. So anyway, all right, this is a good one to put in the memory banks. This is document 354. So let's keep that in mind. Moving on to 356.
What about 355?
I'm sorry, 355. I said that wrong.
You jumped again. 355.
I was looking at 356, but I pulled up 355. So my brain had a small aneurysm. And plaintiff's reply in brief support of partial summary judgment. Okay, this is a 16-page document.
Quick question. What does partial summary judgment versus summary judgment? How do those differ? Does anyone know?
Well, maybe it would take Cherie to explain it, but I'll tell you my layman's non-lawyer, get what you pay for explanation. It's because...
I'll take that.
Okay, so the Second Amendment complaint, as we've talked about many times, Colborn has had to disavow a good portion, if not all of it, but a good portion of it. Talking about his zipper issues, and he's had to walk away from that, and other things that he complained about in his SAC, because they basically have said, like in a lot of their pleadings, they literally talk about other people that have nothing to do with Colborn. They talk about links, they talk about all these other people, but Colborn is not part of it at all. So they've had to back away from that. So in that regard, they've had to basically say, okay, ignore all this. And now Colborn's saying, well, okay, we just want to do a partial on our Second Amendment complaint. And basically, I think they're more narrowly focused now on the trial testimony. So that's my understanding. Maybe Cherie can comment.
Okay.
I'm not so sure that's correct, Jack. Cherie, can you?
Well, I can't remember exactly what he asked for in his motion on that, but like it's where if they had several claims, they think they've reached summary judgment stage on some of them, and maybe it's like Jack said, the other ones they're just don't know they don't have anything on, or else they know that they're going to have a hearing or they believe there has to be a hearing.
Yeah, that's what I'm thinking.
So Cherie, what is summary judgment? Like as short and as a layman as you can make it. Is summary judgment good for Colborn, or is it good for the documentary?
Good for the documentarians.
Who's ever asking for it?
Yeah.
Okay. So so maybe what I'm not understanding, are there competing summary judgments being filed for at this time?
Requests.
Okay,
Yeah.
Thank you. All right. So
go
ahead.
Colborn has asked for partial summary judgment, and the other side has asked for full summary judgment,
which is basically a dismissal.
With prejudice, which means he can't
find in their favor in this lawsuit with prejudice, which means he can't ever file again.
Okay.
Correct.
Okay. So and Colburn's kind of countering this by saying, we will drop A, B, C, and D, but we think we have enough to go to court on E, F, G, and H.
Yeah, basically.
I don't think so. I think he wants partial summary judgment on some of his points. Like, judge, just make a ruling on these points because it's obvious I win these, basically. And then just partial of it. And then the rest of it, I think he wants it to go to trial and to have a jury award him a bunch of money. I don't know.
He's not agreeing to drop anything.
He's willing to in his amended complaints.
Right.
I think he changed some things.
Right. He's wanting the judge to only look at A, B, C, and D that Netflix is saying should be dropped, but E, F, G, and H, and Colburn's trying to say, I have enough evidence to prove we should go to court on these parts. I got it.
Well, no, I'm not. I don't know.
No? Okay.
Because with summary judgment, you're saying, I have enough, judge, to show you that I'm right on this and I should get judgment on it.
Yeah, no jury's going to say the other side won, I win,
Yeah. Right.
Okay.
You just make the decision, judge, and yeah. But I'm unclear on the partial thing.
I'm going to read this. I'm going to read this from Google. It says, the question is, what is the purpose of a summary judgment? And this is kind of brief here. So while a summary judgment motion is not a substitute for trial, it is a tool that allows courts to weed out cases that do not need a trial to be resolved. It also allows the court to simplify and streamline the case so that trial is more efficient and focused on the area of actual dispute.
Okay.
That helps too. Okay.
And did you look up partial summary judgment?
I'm doing it right.
I
So in
put a
other words,
little
go
blurb
ahead.
in the text there. The open mic voice, I guess it is, that about partial summary judgment that I found online. So I don't know if that would help.
Did you link it?
I just cut and pasted the words into the
Oh,
voice.
would you read it, please?
What is partial summary judgment? In some cases, the court may grant a motion for partial summary judgment. The purpose of partial summary judgment is to simplify a trial by ruling on some claims, but not all. For example, the court might rule on some factual issues, but leave others for trial.
Yeah, okay.
Okay. All right. I can accept that. Okay. So does that kind of help explain, Christina? You get a little more
Yes.
clear about it? Good.
So
That
so
makes sense to me
Colborn's
too.
not conceding. Colborn's not conceding anything.
No.
All right.
But he did in his amended complaint change his story about his divorce and so on. I think he conceded that.
You think it was the fact that he got exposed for having an affair that
Well,
made him concede?
Well, I don't know that he conceded it. He did talk about it though, but then he had his wife write a second what do you
Declaration.
call it?
Declaration.
Really? I missed
Yeah.
that.
Yeah, she wrote the second one. She absolutely did.
And what? So can you give me the highlights?
Well,
I'm so far behind. What
She
Well-
kind of backed off on some stuff, didn't she, Jack?
yeah, it wasn't quite as harsh as the first one she wrote, but I mean, she basically, as I recall, she talked about, remember we picked up the fact that he told her he thought he might go to prison, might go or get put in jail during the trial, and
Yeah.
she did point out that say that again, sir.
Guilty conscience. That's what I think.
Well, yeah, absolutely. And then she did talk about maybe not much in the harsh term as the first declaration, but that the affair did cause the divorce. But yeah, as I remember, it wasn't quite as harsh as the first one that she submitted. And it seemed like it was shorter too. But yeah, we've read so damn much, I can't remember exactly.
Yeah.
Anyway, let's get to this next one here. This is document 355. We're almost to the end of what Sherry has gotten us so far and has been filed. Keep in
I
mind,
think it's probably going to explain a lot of his partial summary judgment request.
Yeah, I think you're right. And keep in mind, there were some documents that were restricted that Sherry could not get. So it is what it is. Maybe at some later point that will become unrestricted. But we'll see. All right. Anyway, I'll start this off, and I'll probably will hand it off to one of the ladies. So hopefully my reading voice is okay. Can you guys hear me all right? I hope I'm not. Everybody's a little weird about. I'm a little weird about hearing myself read on.
You sound great, Jack. You sound great.
All right. Okay. All right. Plaintiff's reply. This is Colborn's reply brief in support of partial summary judgment. Introduction. Plaintiff moved for partial summary judgment with respect to several issues concerning defendant's republication of defamatory third-party statements as part of their, quote, making a murderer, ma'am, broadcast, including 1, publication, 2, defamatory meaning, 3, actual malice, and 4, falsity. As further explained below, defendant's responses fail to proffer any legitimate reason to deny the motion under the unique circumstances presented in this case. Argument. 1. Defendants do not dispute publication. Defendants' responses do not appear to mention nor contest their publication of matter. 2. The third-party allegations repeated in MAM are defamatory. Netflix and Chrome each argue that there is nothing defamatory about the statements that are contained in MAM and that are not identified in plaintiff's motion for partial summary judgment. Defendants largely rely on the tactic of considering each statement in isolation and out of context. As plaintiff has explained on numerous occasions, Wisconsin law requires that a broadcast be considered in its entirety for purposes of a defamation claim. And cites Mock v. Al.
Now they're using the opposition's reasoning.
Tactic. Yeah. And here's another citation, Rodney Smolla Law of Defamation. The statements are identified by time of broadcast in Mr. Colborn's initial brief to assist the court in locating the statements in MAM, and they are presented together in a chart because they collectively form a narrative that runs through the broadcast, which accuses Mr. Colborn of planting evidence. Contrary to the defendant's arguments, it does not take a sophisticated linguistic analysis to discern the recurring accusations from the statements. In fact, it is directly stated on more than one occasion, to the extent that the defendants contend that it is difficult to understand the accusation from third-party statements identified in Mr. Colborn's initial brief. Plaintiff provides the following simplified synopsis. First bullet point, the statements identified from episodes 1 and 2 at pages 6 through 8 and most of page 9, Mr. Colborn's opening brief, docket 285, collectively set up for viewers the notion that Mr. Colborn is someone who had an axe to grind against Stephen Avery because Mr. Colborn allegedly mishandled a call to the Manitowoc County Jail years prior to Mr. Avery's release from prison, with images of Mr. Colborn woven into the statements of Stephen, Glenn, and others to emphasize Mr. Colborn as a key figure in an alleged quote-unquote cover-up. Next bullet.
That's just what happened.
Yeah, they were talking about him, so why not show his photo?
And Netflix didn't make that up.
No.
I mean, the judge allowed the defense to point the finger at them.
Do you
Colborn
see how,
Colborn and Link?
Yeah.
and notice how they said from Avery's release in prison, not his release after spending over a decade wrongfully in prison, right? They don't actually spell out what happened. They tell the truth, and I loosely define that as truth, in as broad and as generic as possible to minimize what was done to him.
It's context, right? We're talking about context, and and you're right, they left it out. It's ridiculous. Okay, next bullet point, and I'm not sure we'll get to the footnote here just in a second. The statements identified on page 9, starting with Mr. Avery's statement, quote, "All I can think is they're trying to railroad me again," end quote. And though, quote, "see if somebody else plants that shit there, you ain't gonna see," end quote. From the bottom of page 9 through the first two statements identified on page 10, docket 285. Transition from the prior alleged quote-unquote cover-up to Avery's accusations during the Halbach investigation that Sheriff's Department officer planted evidence against him in connection with the new investigation. All right. I'm going to highlight this because, just to make it a little easier because it's smaller. So footnote 1, this is pretty long. The defendants also provide false and inaccurate information about the call Colborn received as a jailer long before he became a law enforcement officer. An anonymous caller told him someone was in quote-unquote jail for quote-unquote an assault that he may not have committed. See docket 120 and talked about the depositions. As a jailer, Colborn was responsible for passing the information on to others in authority, a responsibility he fulfilled. But Ma'am omitted that information and instead quoted Stephen Glenn, one of Avery's attorneys for his civil section, 1983. It was actually 1985. They've done that wrong. 1983 case against Manitowoc counties, who inaccurately related the caller informed Colborn that the man was quote unquote in prison, not jail, for a quote unquote assault rather than assault, and added that Colborn should have written a report, something that as a correction officer, Colborn could not do. A fact his 2005 deposition testimony confirmed. And it lists the dockets there, the various ones, that omits mentions of Colborn's status of a corrections officer until episode 5, which ends with Colborn's 2005 call to dispatch as a cliffhanger. The defendants knew of these inaccuracies since they possessed Colborn's 2003 statement and 2005 deposition testimony, which appeared in Ma'am, and it gives the dockets. And I've talked about this before, and I'm just going to mention it again. And, maybe I'm wrong, maybe I'm not. But when a detective from another county calls another jurisdiction, I can't help but believe that there's not some kind of identifier that they have to provide. It can't just be say, hey, I'm Detective Joe, I'm from Brown County, and I've got some information. Because if that were the case, anyone could call and say, whatever. And that's just me. And they would certainly identify themselves. I can't believe they wouldn't identify, right?
Well, here's what's interesting. Since you've been saying that, it's been spinning in my brain. And if you listen to dispatch calls, I believe it was Herman who tried to tell the dispatcher, hey, anyone who calls from Cal County or DCI, run reports for them. And the dispatcher says, yeah, but how do we know they're who they say they are?
Exactly.
And yeah. And she wasn't going to do it. So if she wasn't going to do it, if she knew enough not to do it just on their name, and no one else is going to just say, I'm going to take their word for it, even Colborn. Also, I'm pretty sure they're misrepresenting the facts, because I feel like we knew by episode 2 that Colborn was a officer at the jail when he took the call.
I think we did, but I know that the jailer's oath is not as expanded as like a regular officer. I'm sure their pay is less, but in any event, he's still an officer.
That's right. He was still a sheriff's deputy.
Yep.
For Manitowoc County. It wouldn't surprise me if he wasn't hired in that capacity, and it wouldn't surprise me if he wasn't actually a sheriff's officer. Just his job title was jailer or corrections officer. It would be interesting to see how they labeled it.
Well, in any event,
I'm curious, why did they make such a big deal that the caller told Colborn that he had somebody in jail or in prison?
Yeah.
But, why did they make that a point?
Yeah, that is curious.
Netflix used the wrong word. Or
I don't know. Again, I think it goes back to any jailer or someone in that capacity that gets a call from another jurisdiction, and these people are not identified.
What are they saying?
He didn't fucking write it down and say, "Hey, I got this detective that's calling me from another county, and he's saying we got the wrong guy in jail. I'm sorry. I'm not a cop. I've never been a cop, but I just think that's detail has been completely ignored.
Yeah. And I also think that I also think that Susan's right. I think that they're trying to switch what was said to make it look like it makes a difference.
Yeah, exactly.
Yeah. I agree.
And as the jailer who is in charge of these inmates, wouldn't you want to know what the fuck's going on with that?
You damn right.
Yeah.
I sure would.
Yeah.
Yep. All right. Let's move on.
And we all know that from Griesbach and I forget who else's testimony that Colborn talked about this call when he took it in 96 with everyone. Like everybody knew about that call. They just didn't write it down.
Well, I think you proved that with that document you got with Couchet and him questioning those other detectives. Without a doubt, they knew damn well about it. Absolutely, they did. I believe that 100%.
And he's trying to say, hey, man, I'm just a jailer. This had nothing to do with me. So all I had to do was transfer the call,
Yeah. But you know what offices can be like? You know what I mean? People standing around the coffee machine on their break, having a natter, you know what I mean? And it's here, by the way, did you hear this? Or, so it's bound to have been talked about. So, for him to go back and question, right, what have you heard? Who told you that? You know what I mean? They knew. They definitely knew.
How far is Green Bay from Manitowoc anyway?
40 minutes, 50 minutes at most.
All right. So when Gregory Allen got knocked off again and that DNA come back, I find it very hard to believe that it wasn't in the paper and that they weren't talking about it, that Gregory Allen had got pinched again. Because he was just prolific in what he did.
Oh,
and
he was
an operator. I mean?
He was an operator in that county, no doubt.
Yeah. Everybody knew about him.
Sure.
Yeah, and just to go back to your partial summary judgment thing, Christina, Cherie's put in the chat. In some cases, the court may grant a motion for partial summary judgment. The purpose of partial summary judgment is to simplify a trial by ruling on some claims, but not all. For example, the court might rule on some factual issues, but leave others for trial.
There you go.
Thank you, Cherie. Thank you, Alice. That makes a lot of sense.
Absolutely. All right, let's move on. Next bullet point. The next three sets of statements include unidentified pool hall patrons confirming that Mr. Avery was framed by Manitowoc County Sheriff's Department for Miss Hallbach's murder. Docket 285 at page 10. The next statement includes Avery's statement that his sister, that, quote, they figure they just got away with it, an obvious reference to the civil suit settlement for the prior wrongful conviction, and they can do it again, end quote, docket 285. In the next two statements,
Wait
Avery's
a minute.
Yeah.
Wait. Would that say an obvious? Go back there.
Yeah. An obvious reference to the civil suit settlement for the prior wrongful conviction. They can do it again.
They figured they just got away with it.
Yeah.
Oh, okay. Yeah.
Yeah. In the next two statements, Avery's new criminal defense attorneys, Dean String and Jerome Buting, first muse about officers' alleged motivation to plant evidence and then directly accuse them of doing so. Quote, they thought we were going to make sure he's convicted. And bolded, they helped it along by planting his blood in the RAV4 and by planting that key in his bedroom, end quote, docket 285, page 11. These are out-of-court statements that appear to be made in interviews.
So?
Yeah, that's right. That's their belief. I mean, so what?
Right.
That was part of their defense, and that's why Willis allowed them to push Lincoln Colborn further in their question.
How is this malice from any of the
Well, it's not.
defendants?
Again, it's a mischaracterization. To me, it is a complete. Yeah. They're trying to manipulate the judge and saying, "Hey, these lawyers said this in the Making a Murder, so therefore it's Netflix's and the filmmaker's fault." Bullshit.
What did Lita Walker? What did that thing say? It said malice is when you know something didn't happen and yet you report it like it did.
Correct.
This is the opposite of malice. All they did was report what happened.
That's right.
Yeah. And no matter how they twist it, it doesn't change the fact that this is what happened and this is what Netflix said happened.
And to say someone's not allowed to say this, have an attorney, the attorneys to not have an opinion, it's bucking censorship to the nth degree. I'm sorry, it's not malice. Go ahead, Alice.
And it's not just the attorneys having an opinion. This is the defense's argument.
That's right.
Against guilt.
Yep.
You know, if Laura and Moira put themselves on camera and somewhere during the show and said, "We believe, that Colborn set him up," and okay, maybe that's malice. I don't know.
Well, or add to that, Susan, we're going to make a documentary and put a bunch of stuff in there that we know is not really true. That's malicious. That's malicious.
That's malicious.
Stephen's defense never argued this at trial.
Right.
See, that's the key. The key is this was his defense.
Correct.
That's the key. If Stephen Avery hadn't went with the planting defense and Laura and Maura had presented a documentary claiming the cops framed him, maybe that would be defamation. But with the evidence, I still don't think it's defamation because there's overwhelming evidence that he's wrongfully convicted.
Correct. And this was part of their defense. Part of their defense. And I'm sorry. Yeah. Anyway, let's move on to these next statements. In the next four statements, Buting continues discussing the framing allegations, then asserts that the sheriff has a quote unquote strong dislike for Avery, and therefore the attitude would quote permeate the upper echelon end quote of the department, including quote the lieutenants and the sergeants end quote. At this point, Mr. Colburn's and Jim Link's photographs are shown as suddenly illuminated compared to other photographs in the supposed department photo hierarchy, docket 285. After the sequence revealing supposed tampering with a vial of Avery's blood that had been stored at the courthouse, Buting says, quote, some officer went into that vial, opened it up, took a sample of Stephen Avery's blood and planted it in the RAV4, end quote. Again, this is an out-of-court statement. Defense arguments to the jury at the Avery criminal trial sidestepped such direct accusations. The defense argument was that any reasonable doubt as to whether the officers would have planted evidence should compel a quote-unquote not guilty verdict. Docket 330-19. Wow.
So they're saying Buting's opinion is malice.
Correct. And there's just no way. That's just what he believes half these guys did. That's not malicious. That's an opinion.
No. Right.
Okay. Next bullet. In the next three statements, first Buting states again out of court, quote, somebody knew that Miss Halbach's vehicle was there before they ever went there. I'm convinced of it, end quote. Docket 285. A brief segment of an apparent interrogation of Avery follows, in which he tells the interrogator that he is told that, quote unquote, a cop put Ms. Halbach's vehicle on his property and, quote unquote, planted evidence. Ma'am next cuts to footage of Mr. Colborn about to testify. At the conclusion of the same episode, Mr. Colborn's edited testimony appears to show him admitting to his call to dispatch that made it sound as though he was looking at Ms. Halbach's vehicle when he made the call. But he said he wasn't. They showed that in his in-court statement. He said he wasn't looking at it.
He did. But they made it appear that way.
Yep. All right, I'll read this footnote number 2. Actual malice, especially reckless disregard, depends as much on what the defendants failed to do and say as it does on what they actually did and said. Here, the defendants advanced an elaborate story that Colborn discovered the Halbach vehicle, and none too subtly suggested that Colborn or others serendipitously transported the car to the Avery salvage yard to plant that evidence. To accomplish this exposition, they altered Colborn's trial testimony to attribute answers to him he never gave and ignored the most basic of evidence that refuted the thesis. The Manitowoc County Sheriff's Department record. It probably continues somewhere.
Bottom of the next page.
It is. I'm going to highlight this too. It's dispatcher log records in real time. The calls dispatchers receive. The November 3rd log showed both a call likely from Investigator Wiegert to Colborn as the officer in charge at 1834 reporting Halbach and her vehicle missing, and a call likely to be Colborn's call to dispatch. And they got these likelies in here. To be Colborn's call to dispatch 3 minutes later at 1837, verifying the basic vehicle information.
Nah, that's not the time he called verifying that.
No, it was at 9:20.
9:22?
That's right. It was 9:22. It was 21:22, as I remember that. We're thinking about the incident.
And they're saying he called 3 minutes later.
Yep. Yeah, but okay, docket 289. This corroborated Colborn's explanation in testimony, docket 290, of the call. Ma'am featured but distorted, yet ma'am never mentioned the document. See plaintiff's response to the Chrome defendant's statement of proposed material facts. That lays out the timing of facts Colborn's call to dispatch. While defendants have vaunted their investigation's detail and thoroughness here and elsewhere, they never explained the absence of this most basic of records from the documentary. One obvious explanation is that the defendants wanted nothing to do with the records that undermined their central thesis. This is a classic. That is a classic display of their reckless disregard of the truth. Contrary to the defendant's arguments, the evidence of actual malice in this case does not consist solely of the failure to investigate, but rather includes selective investigation and presentation of facts, distortion of the plaintiff's own testimony and appearance, and defendants' communications that unmistakably expose their joint efforts to sculpt ma'am toward a preconceived narrative that portrayed plaintiff as a key participant in a conspiracy to plant evidence against Avery. Well, they got some likelies up here. Likelies are not fact.
Nope.
Got him.
I can't believe they're misrepresenting that time that he called.
I know, because narrative log 8844 of that incident, there was an attempt to locate, I think, that went out at 1837. I think that's right. Mm-hmm. And that contained everything that was sent out to all patrol. Mm-hmm. So to me, they're confusing this ATL and the narrative log as Colborn's call. That was not his call.
Nope.
Okay. Our next bullet point. In the next identified statements, Buting explains, again out of court, that only 2 or possibly 1 officer would have had to conspire to plant evidence, concluding, quote, you know, who better than a police officer who would know how to frame somebody, end quote. Big deal.
So,
Well, and in the next identified statement, Avery's father directly accuses authorities of setting up Avery, stating, quote, they set him up right from the beginning, end quote.
so
I tried to say that like
Oh,
son of that son of a
they
bitch.
set him up right from the beginning.
Yeah, I mean that's exactly it. So how is that anything to do with the document to the defendants? You know what I mean? They didn't make Alan Avery say they set him up, or they done it to us 20 years ago, so they're doing it to us again. You know what I mean? The defendants can't help the people that were in the bar that were saying, oh, they set him up. You know what I mean? It is fucking pathetic that
Not
they
malice.
are fucking going this far.
They're pissed off that they included that in the documentary.
Yeah, it's not malice, though.
No, it's not.
Okay, this next one. The next identified statements include an exchange between Buting and String in which they appear to discuss the alleged planting of the key in Miss Halbach's key in Avery's bedroom, concluding with Buting stating that, quote unquote, bottom line is that, quote, they knew their boss had just recused the department and turned over lead authority in this investigation because of that lawsuit. They were deposed in that lawsuit. They didn't tell, end quote, and that's at docket 285. The statements obviously refer to Mr. Colborn and Mr. Link, members of the Sheriff's Department, who had both been deposed in Avery's civil suit, as had been described in detail in episode 2, and who were both in the room at the time that the key was discovered. Yeah, they sure the hell were. Transcript, you know, in here, they've clearly left out what Crest did at the end of the trial in his closing and ran from that damn key. Can't we just set that key aside? Because he knew how bad it looked. They sure didn't include that in the next identified statement from the same, episode 7, Avery's voiceover is used to again accuse Mr. Colborn and Mr. Link of wrongdoing against him, stating, quote, I'm in the same situation I was before, just a couple of them waiting to nail me. I got to go through this over and over, end quote. Docket 285. In light of Buting and String's prior statements in the same episode and prior episode statements in which Mr. Colburn's and Mr. Link's photographs were illuminated by Ma'am, and in which Mr. Colburn's testimony is juxtaposed immediately following Buting and Avery's accusations, respectively, that, quote unquote, some officer and, quote unquote, a cop planted Miss Halbach's vehicle on the Avery property. It is obvious that Mr. Colborn is being referenced as one of the...
It's obvious.
yeah, quote, couple of them in wanting to nail Avery. However, in case anyone might have missed reference, Ma'am dispels any doubt by immediately juxtaposing, I'm saying that wrong. Juxtaposing, thank you, an image of Mr. Colborn as Avery continues speaking, then juxtaposes images of Mr. Colborn waiting to testify and Avery looking sad.
Jesus.
This is so desperate. In the next identified statement, a question by a reporter to Dean Strang speaking out of court concludes that with Strang shown asserting that the quote unquote evidence against Mr. Colborn, who was directly referenced in the reporter's question, is stronger evidence that has been used to prove conspiracies in federal court. Yeah, he did say it. Big deal. Later in the same episode, Avery's mother states in a telephone conversation that, quote, it seems suspicious, end quote, that, quote, them people ain't going to get away with everything, end quote. Another reference that builds on all prior accusations against Mr. Colborn.
Jesus. Boy, they're inferring a lot of shit, aren't they?
Yeah, they sure are. They're making some serious leaps of faith here. There could be no reasonable there could be no reasonable argument that educated, intelligent persons such as the representatives of Netflix and Chrome who produced MAM could possibly have failed to appreciate the collective impact of accusations by Avery, his family members, and attorneys that Manitowoc County Sheriff's Department officers planted evidence to frame him for Ms. Halbach's murder. In fact, they did. Docket 330.
They did frame them? Is that what he's saying?
Well, no. That they presented it. In fact, they did. MAM emphasized at every turn that these accusations pertain to Mr. Colborn as noted above, through juxtaposition of videos and other gimmicks designed to draw attention to Mr. Colborn while they were repeated. Well, it wasn't just Colborn. It's not just about Colborn.
No, it was officer, the Manitowoc County Sheriff's Department. It was the whole fucking department, because the whole department, that nobody for the department should have been on that fucking property when any evidence was found. So it was all the officers that they were referring to, not just fucking tosser-faced Colborn.
Well, as it even goes further than that, it goes to the baby. They had to be babysat. What does that tell you? And that's from their own information. They knew that they shouldn't have been on that damn property.
Yeah.
So, all right. Also, contrary to defendants' arguments, these accusations are never genuinely disputed by anything in MAM. Rather, statements made by law enforcement and prosecution, quote-unquote, characters in MAM were included to let them have, quote, have their day, end quote, as a prelude to retelling their perspectives by, quote, our more reliable narrators, end quote. Example, Avery and his advocates thereafter. Let's see docket 330. And then Manhart 493. Further, supposedly including a cautionary statement does not insulate the publisher from liability for a defamatory statement where the quote-unquote unmistakable theme of the publication is to the contrary. They cite a case there, Hatfield versus New York Times. This rule is only common sense. Otherwise, every person could defame anyone else with impunity through simple artifice of tagging perfunctory, quote-unquote, but he denies it after accusation of all manner of reprehensible conduct. Indeed, ma'am, the denials were altered deliberately, misrepresent the manner of Mr. Colborn's testimony. Another cited case. So the denials that defendants claim exonerate them from additional falsehoods. Having weaponized Mr. Colborn's own statement against him, defendants cannot credibly claim that the statements soften the blow of third parties' direct accusations. But to the extent that the statements may be construed as ambiguous as to whether they are defamatory to Mr. Colborn, a question of fact will be presented for the jury. I just got to say, he denied he was behind the RAV4 when he read off that plate to the dispatcher. He denied it, and they played that in court. So he had a chance to and was given that option. Anyway. Comments? Don't break anything, guys. Come on, don't break nothing.
God, it's just...
Yeah.
They're so dumb. That's all I gotta say.
Yeah, it is. It is pathetic. And trying to bring in other people like Alan Avery and stuff like that. I'd see the point if Alan Avery said, aye, that fucker Andrew Colborn is fucking setting him up again. You know what I mean? And then be different. But he says, no, he says they're trying to set him up again, meaning the law enforcement themselves. And I'm sorry, but I'm not fucking sorry, because I watched it. And I watched it from beginning to end, and I've watched it a few times now. But with the first time I watched it, by the second fucking episode, I had a gut feeling that they fuckers set him up.
Well, at least something screwy happened, right? Something weird's going on here.
Yeah, I mean, to me, Jack, it was the fact that he gets out in 2003, and then by 2005, they're rearresting him again for a murder. You know what I mean? The guy's just spent 18 years in a fucking jail for something that he did in a day, and he's out 2 years, had that freedom, tasted that freedom, knew that he was going to get money in that coming to him, but then goes and does something fucking stupid, like murder a fucking photographer. Really? Are you fucking serious? You know what I mean? So by the second episode, I was like, no fucking way. They've set him up again. So, immaterially what Alan or that says, the cops' actions and their fucking non-actions is what made me decide that they set that man up again and took down a fucking 15-year-old child in the fucking process. It's disgusting. And for him to go through this and pick out all this fucking pernickety shit is unfucking believable. And I hope to God that the judge sees right through it and throws the fucker out.
With prejudice. Can't be filed again. I do too.
Yeah.
All right, Susan, do you feel like reading some more of this tripe? Starting with number 3?
Sure. Defendant's arguments fail to redeem Ma'am's third-party accusations. Defendants wrongly characterize Global Relief Foundation, Inc. v. New York Times as controlling authority. As defendants have acknowledged in other submissions, in this diversity case, the court applies the law of the state in which it sits, which means that Wisconsin law controls. In Wisconsin, the defense of quote-unquote substantial truth can excuse quote, slight inaccuracies of expression, end quote, or a defamatory charge is, quote, true in substance, end quote. However, a false statement that a person has been charged with or committed a crime, quote, is not a slight inaccuracy, end quote. The defense of substantial truth does not, quote, unquote, sanitize glaring falsehoods, even when presented in a, quote, series of true or substantially true statements, end quote. Further, as plaintiff explained in his prior submissions, Global Relief concerned reporting about a party that had been investigated by a government agency for misconduct. In contrast, here, defendants made direct accusations against plaintiff and others that were not leveled by any government actor, but only by a convicted murderer who was attempting to cast doubt on his guilt. It's like a footnote.
There is a footnote. Hold on. Yep, not too long.
Contrary to suggestions by Netflix that no reasonable person would give credence to the assertions of a convicted murderer, production notes show that defendants intended to inspire confidence in Avery. Defendants sought to titillate viewers with a story that portrayed the Averys as quote-unquote underdog heroes. Manhart 63, and law enforcement as corrupt. Moreover, that defendant, Avery, did not even testify at his trial, yet many of his direct accusations are included in Ma'am. The defendant's broadcast had more quote-unquote sting than the Avery trial is evident in the reactions Mr. Colborn encountered after Ma'am. In Finn Fiduciaries LLC v. Gannett, on which defendants also heavily relied, the court considered a newspaper defendant's reporting about a financial advisor who was sued for mishandling funds. The newspaper's reporting about the allegations against him and the ultimate holding of the court that he engaged in quote-unquote bad faith were reported. Here, defendants buttressed the magnified theories that a convicted murderer's counsel suggested could provide reasonable doubt, and through statements that were never made in court and juxtaposed video imagery, made them into express and implied factual accusations that were published after the criminal conviction and that directly accused Mr. Colborn of planting evidence to ensure the conviction. The facts of this case are worlds apart from those considered in global relief and financial fiduciaries. Nor is this case about quote-unquote interpretation of quote-unquote ambiguous source materials, as Chrome argues. Defendants deliberately enhanced and republished express accusations of criminal conduct based on the word of a convicted murderer. If quote-unquote rational interpretation authorized false accusations of criminal conduct, it would swallow defamation law whole. What?
Yeah.
4. Defendant's actual malice can be determined as a matter of law. Defendants argue that their alleged subjective intent cannot be determined on summary judgment as a matter of law. Plaintiffs agree that in many, if not most cases, the question of subjective intent is an actual malice determination, should be determined by a jury. Aramo v. Rolling Stone. Reconsideration granted to submit to the jury whether certain statements were quote-unquote of and concerning plaintiff. But a party is deemed to have subjectively intended the obvious consequences of that party's actions, and external indicia of subjective intent, not an quote-unquote ontological analysis of a person's quote-unquote inner thoughts, is necessarily the basis for determinations of subjective intent. Heller International Court v. Sharp. In defamation cases particularly, a defendant's subjective intent may be established by circumstantial evidence, including evidence of the defendant's actions. On summary judgment, only reasonable inferences are considered. Here, as explained in plaintiff's initial brief, defendants acknowledge that they created and or viewed and approved MAM. There can therefore be no dispute that they were aware that the third-party statements were contained in MAM. Further, as explained above, does not take a sophisticated linguistic analysis to understand that the statements viewed in their totality, and some individually as well, accuse Mr. Colborn of planting evidence to frame Avery. Moreover, numerous viewers obviously understood the accusations, as explained in plaintiff's initial brief. There is simply no reasonable inference that can be drawn from the facts to support defendants' bare allegations that they were unaware of the defamatory nature of the third-party allegations, or that any such interpretation was accidental, when so many irate viewers knew exactly what the statements conveyed, and defendants' own communications urged shaping the content so as to make viewers, quote-unquote, terrified and enraged. Further, while defendants claim that those who contacted Mr. Colborn were, quote-unquote, unreasonable for doing so, that does not mean that their interpretation of MAM's accusations was unreasonable. Yeah, you can't prove that those people even watched MAM.
You know, that's right.
They pointed out.
And it comes back again to the basic premise that a documentarian or hell, even a news reporter can't go and question someone in any town USA or whatever.
Yeah.
And they give an opinion that Officer Joe has framed.
He's a liar.
That's right.
Yeah.
This would completely, because these are third party people with their own opinion, and we're allowed to state our opinion. I mean, it's just that simple.
Right.
And they're saying, no, you can't present that. Can't do it. And
Yep.
Anyway.
I'm going to let somebody else continue.
Alice, you want to read a bit? Number 5?
Problem. Number 5. It is not plausible that the accusations were published in ignorance. Defendants also argue that St. Amant versus Thomas does not support the proposition that actual malice can be proven by reliance on sources whose credibility the publishers has obvious reasons to doubt, but other courts have interpreted it as so holding. See Harriet Hanks Communications versus Canonot. In a case such as this involving the reporting of a third party's allegations, recklessness may be found where there are obvious reasons to doubt the veracity of the informant or the accuracy of his reports.
Well, I'm sorry, there is no obvious reason to doubt it. Right?
That's right.
Yep.
My thoughts exactly, Susan.
Yeah.
I mean, it's not like somebody walked into a theater and yelled fire when there's absolutely no fire going on to create an issue. I mean, that's not defamation, but it's along those lines of saying you're not allowed to say, a person is not allowed to have an opinion, and it's completely ridiculous. Anyway, continue.
Yeah. Recklessness may be found where there are obvious reasons to doubt the informant. Courts likewise agree that reliance on inherently improbable statements or information that is obviously dubious may show actual malice. And in case law again, upholding the actual malice finding where there are sources' own manner of speaking raised quote-unquote obvious doubts about the quote-unquote veracity of the speaker. Butowski and Flockenflick.
None of this freaking applies.
No.
If you ask me.
No. Quote, debunked an unreliable source. Uploading actual malice finding where publication cited unreliable affiant. Further, biased source is recognized as quote-unquote likely an unreliable one, unquote, for purposes of an actual malice analysis, particularly where the source carries an evident grudge. What?
Well, they're saying somebody like Alan Avery that has had trouble with, the Manitowoc County Sheriff's Department may have a grudge, so therefore, you can't really. His statement shouldn't have been included. That's what they're trying to say because they included what we have here, like 4 case laws that they've included in those 4 ones we didn't read. That's what they're citing here. All these cases, you can see it there.
Any intelligent viewer is going to know that Alan is going to have bias towards Stephen.
Of course.
Of course. They stole his son away from him and put him in jail for 18 years for something that he didn't do. Any family member, I don't care who they are, any family member that has went through that and seen their son, their daughter, their brother, their sister, or whoever go through that kind of thing, of course they're going to have a hard opinion on the cops. No matter what state or country.
Alan knew Stephen was innocent because he was with him.
That's right.
That entire day, doing the cement thing.
The 1985 case, absolutely.
Yeah, he had 60 witnesses on his side to say that they were with him or they seen him or whatever. You know what I mean? And they still didn't fucking listen to them. And they still sent him away for 30 odd years, because he was sent to 30 odd years. I mean,
34.
yeah, because I've thought about that for a while now. You know, if Stephen didn't get exonerated in 2003, his time would nearly be up. You know what I mean? It's madness what this guy is trying to do and trying to say, because people have an opinion. Well, your opinion is that fucking Stephen Avery is guilty. Does that mean it's malice because he's no guilty?
Right. It's an opinion, you know, and that's what this all comes down to. Anyway, continue.
Oh, that a defendant shaped facts to conform to a preconceived narrative is further evidence of actual malice. Number 32, something the producer's public interview corroborated happened here from the start. Miss Demos and Miss Riccardi related on the podcast the quote-unquote the crime story. They promised Stephen Avery, quote-unquote, to tell his story, and cultivated Avery and his family in order to win their trust. Below is a link to the story that was produced in Discovery as Colborn 4918 to 495. They grew close and built a quote-unquote rapport so as to foster that relationship. Quote, it was very intimate, unquote, they said. From the onset, they regarded Stephen Avery as the programme's protagonist and law enforcement as his antagonist. Also see Ricardo testimony, docket 330-1023. Regardless of what the defendants claim now, they endeavoured to create a false narrative that Colborn and members of law enforcement framed Avery for a murder he never committed.
Bullshit.
They did not.
That's such bullshit.
To create the false narrative. They didn't create it. It's what was at trial.
That's right.
It was already there.
They didn't create anything. They tried to present what had already happened and was happening.
Yeah.
Wow.
Defendants repeated and fortified accusations by a convicted murderer and his family members, and juxtaposed plaintiff's images with those statements in a way that implicates him in a criminal conspiracy. This is the rare case in which reckless disregard for the truth cannot plausibly be disputed, particularly given defendants' hunger for a story so inflammatory that viewers would be, quote, shouting at their television sets across the world, unquote.
I want to correct something here, because they've done it twice or three times, taking statements as truth from a convicted murderer. Well, when this was going on, he hadn't been convicted yet. He had not been convicted yet. So this is a misrepresentation. I mean, you could take it, as truth, I guess, after the fact, but during the time, in real time, that hadn't happened yet. Anyway.
And also, calling him a convicted murderer does not make Stephen a murderer.
That's right.
Just because he got convicted.
That's what the jury came back with, but, that's a whole other 10 podcasts.
That's how you like to do it, Susan. They've got to. They can't. It's the same way media outlets and that. They cannot just turn around and say Stephen Avery. You know what I mean? They've got to say the convicted murderer. And I've learnt that lesson with Luke's case. Because every time that Luke is mentioned in the tabloids over here, it's convicted killer, the murderer. You know what I mean? They can't just say Luke Mitchell. They've got to have the emphasis and ground like that on they got
to put a label on it. Absolutely.
Yeah, exactly.
And I'll just say hello, Travis, and you're absolutely right. They're arguing evidence, standards, and requirements for motion for summary judgment. Partial summary judgment. Yeah.
Hey,
Okay, number
Travis.
6. Hi, Travis. Defendants admit that Mr. Colborn testified to the falsity of, quote, planting evidence, unquote, accusations, and they can produce no evidence in response. Defendants argue that Mr. Colborn must iterate his prior testimony denying that he planted evidence in order to put the falsity of any quote-unquote planting evidence claims an issue for purposes of summary judgment, because his prior testimony is inadmissible in this case. But in fact, Mr. Colborn's prior testimony may be admissible as a prior consistent statement at trial, for example, to support Mr. Colborn's testimony when his credibility is challenged on another ground, such as defendants' litany of irrelevant accusations in their respective briefs, should any of them be admitted at trial. See Advisory Commission Note D. Under the rule, the prior consistent statements are substantive evidence. Further, this is a non-issue because defendants admit in their own proposed findings of fact that Mr. Colborn has denied under oath that he planted evidence, docket 326. Crome proposed finding of fact, number 59, Mam shows Mr. Colborn testifying that he never planted evidence, docket 323. Netflix, Mam includes Mr. Colborn's denial at the Avery trial that he planted evidence, docket 323. Colborn testified that Avery's civil lawsuit did not cause them to plant evidence. And then stating case law, on cross motion for summary judgment, all materials are considered. Defendants affirmatively posit that Mr. Colborn has denied under oath that he planted evidence. In response, defendants offer nothing that could possibly be construed as evidence that could overcome Mr. Colborn's denial. To the contrary, they re-allege the rank speculation that Mam portrayed as unrefuted facts, allegedly buttressed by inadmissible hearsay and lay opinion observations of a former juror, which contradict a reasonable view of the raw footage of Mr. Colborn's testimony as provided by defendants. See docket 312. And inadmissible hearsay and lay opinion observations from defendants' former counsel, 339. Defendants also use their brief as an excuse to further attack Mr. Colborn based on a random list of supposed grievances, including Crome's after-the-fact swipe at the stipulation that Mr. Colborn entered into with Netflix prior to his deposition. Crome claims that Mr. Colborn, quote-unquote, falsely claimed that Mam destroyed his marriage, but was, quote-unquote, forced to backtrack, docket 319, page 17. In fact, Mr. Colborn was not, quote-unquote, forced to do anything. He stipulated only that for purposes of this case, he would not contend that his marriage was affected by Mam, docket 213. Excuse me. It is improper for defendants to now misrepresent as fact their speculation regarding Mr. Colborn's decision to enter the stipulation. Similarly, Crome falsely claims that Mr. Colborn violated work policies by participating in an interview for another documentary, docket 319. In fact, Mr. Colborn had obtained his supervisor's permission, docket 317. Moreover, regardless of whether the court grants Mr. Colborn's motion as to the element of falsity that he must otherwise prove at trial for purposes of his claim against defendants, the defendants have also asserted truth as an affirmative defence. See docket 181 at page 29. Fourth defence. Defendant's own authority states that a plaintiff may need to prove literal falsity, but a defendant bears the burden to establish quote-unquote substantial truth, which entails a different analysis. Summary judgment should be granted as to quote-unquote planting offered as alleged substantial truth. Ultimately, defendants' responses confirm that there are no facts that could establish that Mr. Colborn planted evidence to frame Avery. But to the extent that the court may decline to grant summary judgment as to this issue, plaintiff respectfully requests that the court do so without prejudice to a motion in limine to avoid waste of time at trial based on any speculative theories that defendants may seek to introduce. Any such efforts by defendants would be all the more precocious,
Specious.
given that it is now common knowledge that even Avery himself has stated under oath in his post-conviction proceedings that he no longer believes that law enforcement planted his blood in Miss Hallback's SUV, and his counsel has attempted to implicate Mr. Avery's nephew, Bobby Dassey, in planting the SUV, State versus Avery. Avery, document 1065, page 26.
So now she's reaching. They're reaching out to KZ shit now.
Yep. Which has got fuck all to do with this fucking this case.
That's right. Has nothing to do with making a murderer. At least the first 10 seasons, which there's a second amending complaint entails. Wow.
Ah, my word. Number 7. Defendants' remaining arguments are without merit. Defendants' remaining arguments should be disregarded as inapposite or simply meritless, including defendants' belated attempts to attack the Second Amendment complaint. In what appears to be an attempt to revive denied motions to dismiss, defendants criticise plaintiff for allegedly not identifying well enough for them each of the defamatory statements in the 10-episode series. In fact, even though the federal law does not require plaintiff to reiterate each and every defamatory statement, citing case law, heightened pleading standards do not apply to defamation claims in federal court. Plaintiff went above and beyond by attempting to list many of the defamatory statements in separate exhibits to his complaint. Moreover, this court already denied prior motions to dismiss the complaint, concluding that plaintiff stated claims for relief. Defendants also claim that Mr. Colborn's argument that some of Ma'am's statements defame him by implication is a quote-unquote new theory in this case, docket 307, page 8. Mr. Colborn was not required to plead legal theories. However, the second amended complaint put defendants on notice that, among other tactics, defendants defamed Mr. Colborn by, among other things, omitting, distorting, and falsifying material, docket 105. Misleading viewers, casting aspersions against him, implying things, and slanting and distorting the truth and sensationalizing their broadcasts. Moreover, the words, quote, implies, implying, and implicated, unquote, and variance therefore was used to describe Ma'am's defamation dozens of times in Mr. Colborn's brief opposing Netflix's second motion to dismiss, docket 31. Classic defamation by implication, insinuation, and innuendo. Directly implicating Mr. Colborn. Ma'am has repeatedly implicated Mr. Colborn as a member of the alleged conspiracy, replete with express and implied allegations that Mr. Colborn participated in a conspiracy. Several references include, quote, the statements expressly and impliedly accuse Mr. Colborn of both committing a crime and lying under oath, unquote. Statements may be defamatory by implication, insinuation, or innuendo. Defendants also repeatedly chastised Mr. Colborn for bringing this suit without having personally seen the entire series. The series is in the court record. Mr. Colborn's legal counsel represents his legal position as to ma'am, just as Netflix's counsel undoubtedly takes legal action on its behalf, even when its CEO has not read every word of every allegedly supporting document, as expressed in earlier briefing. Mr. Colborn brought suit not because Netflix offended him. He sued because it lied about him, and people who watched the programme believed those lies. Netflix also argues that Mr. Colborn is somehow bound in this civil proceeding by statements made by the judge in Avery's criminal trial while deciding pre-trial motions. Docket 307 at page 9. Netflix, of course, cites no authority explaining how a civil litigant who was not a party to a prior criminal proceeding could be bound by anything that occurs during that proceeding. And plaintiff's counsel is aware of no claim or issue preclusion authority that so holds. The only issue that was finally adjudicated in Avery's trial was that Stephen Avery was guilty of murdering Teresa Hallback, with the jury rejecting, beyond a reasonable doubt, any arguments otherwise. Netflix further bombastically argues that the foundations of Western journalism will crumble if Mr. Colborn's claims are permitted to proceed to trial. In support, Netflix points to examples such as reporting about the criminal trial of Kyle Rittenhouse following the unrest in Racine, Wisconsin, and so arguing Netflix embraces the same philosophy as MAM itself, refusing to acknowledge the distinction between fair reporting about a criminal trial against a criminal defendant, on the one hand, and flat-out accusations by a criminal defendant and his family and attorneys published after a criminal defendant has been found guilty, that someone else was responsible for the crime that he committed and or other crimes. To avoid liability for defamation in cases like this, one need only avoid making enhancing or republishing statements that accuse of criminal conduct individuals who have not been convicted nor even charged. That such statements are actionable by defamation has been the law for centuries. As one court put it, not First Amendment protection enfolds false charges of criminal behaviour, unquote. Citation and quotations admitted. Netflix also includes in several places in its appendix assertions that some republished statements are quote unquote non-actionable opinion. Docket 307. The argument is undeveloped, but Glynn, Avery, and the others' statements imply factual assertions and are therefore actionable. Finally, Netflix includes in its appendix several claims that individual statements supposedly were quote-unquote not about Mr. Colborn. Mr. Colborn must be considered defamed by statements if a recipient could reasonably understand that they referred to him, Wilson and Prime. In their context, There is no doubt that the third-party statements identified Mr. Colborn as planting evidence. Indeed, Netflix celebrated, quote-unquote, setting up Mr. Colborn as planting Miss Hallback's SUV, docket 330. Conclusion.
What?
Yeah, exactly.
Celebrated setting up Colborn.
Yep, exactly.
I'm listening to Alice read this, and I'm just rolling my eyes as I'm scrolling along here. I'm thinking to myself, they're trying to, before she reads the conclusion, to me, they're trying to make ma'am a person. And it's not. It's not. It's the name of a collection of people that gave opinions. There was testimony. There was all kinds of things presented in this whole thing. And I know that when I watched it, I didn't necessarily take everything that was in it as truth. I considered all of it, but it wasn't like
they were opinions.
Yeah, right.
Opinions of people.
To allow this to move forward to trial, to me, I think it is a real danger. I just don't think there's anything to litigate.
No, it's just ridiculous. So because Joey down the road said that he was part of it, and he told Fanny, and then Fanny went on to tell Helen, then that's defamation. You know what I mean? That's basically what they're trying to say. It's just, oh my God, man, it just gets worse and worse and worse, and I didn't think that they could get any fucking worse, but they're just getting worse and worse.
Yep, I agree. Anyway, continue on. Let's get this baby over with.
Yeah, conclusion. Defamation can be especially poignant when a defendant, quote unquote, baits the hook with the truth. Hart Hanks Communications at 37. This case could not prove that point more. Defendants took Mr. Colborn's testimony, together with third parties' statements about him, and treated them like lumps of clay to be reshaped and remolded into a work that they represented as photographically accurate. The intended result was to publish falsehoods about Mr. Colborn that served the story that defendants wanted to tell, regardless of the truth. There is no reasonable inference that defendants repeated the statements in ignorance of their actual effect. Dated this 9th day of December 2022.
Wow. I really thought this would have been authored by Burnett, but it did have elements that he's not quite as bad as he is, but I'm just dumbfounded that they would write this and turn it in.
Yeah.
Travis says plaintiff should have been pounding on the Netflix input into shaping the drama and suspense of Mim. They have done that. They talk about the music and
the graphics.
Setting up the baddies, that they try to use all these elements, and again, in presenting a documentary, this wasn't, they weren't like, I go back to the Heard Depp trial, that was shown, and you could take it as truth without, the sidebars, those were blanked out, but we got to listen to the testimony. That's not what making a murderer is. And to make it, because they even kind of referenced that, talking about the trial, they showed elements of the trial. They showed bits and pieces of the trial. They didn't show it in its entirety.
Travis asked, what did the panel think when they read all of the Netflix documents to Chrome about music, how to end each episode, etc.?
Well, again, I mean, for me, talking about the music, the graphics, they talked about the graphics at length too, because they were showing these different people in their different positions. If you think back to Making a Murder, there would be a cut and it would show a black screen. It would have like Herman and the various people showing these people's position within the department, or possibly who they were. And to me, it helped me as the viewer understand the hierarchy. I think it was a good thing. The music, hey, to me, the music is it's a necessary point to any kind of visual. You can't just have. To me, you couldn't present that and not have some type of background fill in. And the music, one way or the other, I don't really care. At least in that aspect. Now, if I'm watching, Lord of the Rings, I expect to be kind of swept away by the music, but not necessarily making a murder. No, that's my opinion.
They're presenting a story, and the story is told by the trial, the lawyers, the family, and I don't see harm in that.
Yeah, Travis says this series wasn't so popular because it was dry, factual opinions. Netflix packaged it to hook you and keep you everyone does it. And I totally agree with Travis. They do, and they did that. But again, they're in it to make money and to try to tell the story. And to me, to say that they specifically defamed Colborn, I'm sorry they didn't. I've read as much as anyone else has. I don't think they defamed him. He may have felt that way. He hasn't watched the entire thing, but there are certainly a whole lot more people involved here that, you kind of scratch your head and you think, what the hell, man? What happened here? Because even to this day, we're still not seeing the full story. We're just not.
No. I mean, it's not that, as we've said, the music and things like that is in everything. It's in every documentary. It's in every film. You know what I mean? As I said before, can you imagine watching Jaws and no hearing the dun-dun?
Sure.
It's Jaws is coming. You know what I mean? Or watching Psycho when it's the shower scene. You know what I mean?
Yeah.
And When she's getting stabbed, you start playing Jingle Bells. You know what I mean? It is absurd. It is absurd what they're trying to do.
Yeah, again, considering trying to say ma'am as an entity, as a person, because they kind of did that. They tried to do it a couple of times there in this last couple of pages. I disagree with that entirely. I just don't like that representation. That's me, though.
The fact is that Stephen accused law enforcement of setting him up.
Yep.
And his lawyers went with that defense. Netflix did not accuse them. They just showed Stephen's accusations, the defense's accusations, some of the locals' accusation or beliefs. I don't see it as defamatory.
I don't either. I really don't. Well, this next one, this is the last document that we have that Shree's been able to get us, or that's been filed. It's 356. And let me double check that.
Is it short?
No, we're going to do it another.
Oh,
22.
Good,
it's 22. It's 22
we're
pages.
In 4 hours here almost.
Yes, we are. Actually, there's 2 more documents. 357 I didn't load. So there's actually 2 more, and we'll do that. We'll do these another night because it's getting late. We've been at this for a minute.
Yeah.
And
Travis says, did it surprise anyone that Netflix brought in editors, composer, etc., to take this up a level? Well, of course not. They're trying to make it compelling, and they want people to watch it. I mean, that's what they do. That's what documentarians do.
Absolutely. Yep, I completely agree. So with that said, any final thoughts before we jet out of here? Just right quick.
There, he's gonna lose.
Yeah, I was just going to say that, Susan.
He's going to lose. I don't know if Jinx is listening or not.
Jinx isn't on chat. Jinx hasn't been on chat tonight, so I was just going to say he's going to lose.
Cherie, final thoughts on what we went through?
I agree that, yeah, if the judge is honest, I believe he would lose. And he seems honest so far, the judge, I mean. So.
Yep. So far, I've liked Ludwig's reasoning and rulings. And Susan, final thoughts?
Yeah, I'm ready for this case to be finished.
Done and dusted, as we say.
Yeah.
Yeah, I completely agree. It's
now,
been.
Travis says he was a little bit surprised that they brought in editors and et cetera, because they tried to get dismissed because they said they were just the exhibitor, that all they did was show it. So he was kind of surprised to learn that they had a bigger hand in it than, I guess, what they claimed in their dismissal.
Well, yeah,
motion.
you know, right. You know, I'm guessing the truth is somewhere there in the middle. They got, you know, suggestions from these creative people from Netflix and used it, not used it, incorporated it in some fashion to make this presentable. And as, you know, Case 10 and Travis have said, to hook the viewer. Well, that's the whole intent of these documentarians. I mean, but to say that it defamed, I'm just saying, I had a lot of eye rolls during this particular.
Well, they really only had, what, 3 episodes completed when Netflix came on? Is that right?
Yeah, I think they had 2 completed, and they had an outline of the third one. I don't think it was quite done yet. Yeah, I think they had sketched it and had some elements, but I don't think it was quite done yet. I believe that's what that email that we read last night said. This next document that we'll get to the next time, today's Thursday, Becca is on Friday. Let me just save this until Sunday's open mic, and that way we can just be done with it. We get both of them knocked out of the way. This next one is Defendant Chrome Media, LLC, Census Film, and Laura Riccardi and Mordimos reply and support a motion for summary judgment. And it is it's 22 pages for this one. I don't know how long that last one is. I don't have it pulled up, but it'll be interesting to what they say. Hopefully we'll get a reply to this stuff, because Lita, I don't know. I just like. So what's Travis say here? Netflix is in this up to their eyebrows, right or wrong. Their motion to dismiss said, quote, "We are not responsible. We only showed it and distributed it," end quote. Then plaintiff showed Netflix accepting award. That's true. I still think that, you know, again, this is a non-lawyer just opinion, that my opinion, that for them, you know, or any documentarian to present other people and let them say their opinion, I just don't think that's defamation. I just don't. That's me. Anyway, with that said, let's jet on out of here and tell everyone good night. Let me get this pulled over here. So,
good night, John Boy.
there you go. When we'll, like I say, we got Becca's on tomorrow, I think, for Friday, and then Saturday we'll be on with Reading with the Crew. It's scheduled, and then Sunday I'll get it scheduled for open mic for our regular time, and we'll get these last 2 documents knocked out, and we'll be done with it, at least so far. Not to say that there won't be documents filed, because I'm sure there will. So with that said, we really appreciate everyone coming and hanging, especially, you know, the lawyers. I know Travis is really busy, Cherie's busy, and everyone else for supporting, you know, Foul Play and us, and you know, continuing to maintain interest in the case. If you like what we've done, hey, give us a like, a share, subscribe, share the information, get others interested, because again, it's civil, it's interesting, and I really like presenting it. So with that said, this has been a Foul Play production.